objective mention for listing in the motion column to bail applications also. On 27.
27th.
Lost.
Okay.
Regular affair है मैं application so I pay for withdrawal matter
Today.
yes my lord
Why?
it's the only statute matter all the appeals will be released on bail that I have applied for yes.
My lord, I pray for listing of one regular bail application, my lord, on Monday, Tuesday, my lord, 27, my lord. Motion, my lord. Already 72 days in custody, my lord.
Just I'm কেটা কেস ফিক্স করে ধান কেটা কেস ফিক্স হয়েছে আর যে উলাই থাকে ক্যালেন্ডার এখন না থাকে উলাই এইজনে উলিয়াই থয় ডিসপ্লে উলাই চেক করলাম এখন লিস্ট কোন দিলে আর আই নো হাউ মেনি কেসেস টু ফিক্স নহলে ফিক্স কেসেস যদি 60টা 50টা যদি ফিক্স করে না ওঠা মনে on 20 on Tuesday
27, my lord.
have it on Tuesday Wednesday 27th. Okay, 27th.
Obliged.
I think not 31 Lordship. Maybe taken up in a first with them. And maybe in the take one first. Then we there.
February we'll have it on 9th.
Not
Mr. Swenso appears for the petitioner. APP has submitted that the CD is awaited. List the matter again on 9th of February 2026. Interim protection granted earlier continues. Learned Council has, no, Learned APP has submitted that the CD is awaited. Jo likha tha na, you wrote na, CD is awaited. There you write, charge sheet has been submitted.
With an observation.
By CS. Huh?
With an observation, Lordship. My bail will be considered in the trial court, Lordship.
Okay, you cut out this order. But Mr. Swenso, Learned Council appearing for the petitioner. Mr. KK Parashar, Learned APP has submitted that the charge sheet has been submitted in the case by charge sheet number
809 of 2025, dated 27/12/25.
Step. The petitioner was on interim bail during the pendency of this petition. Stop. The Learned Council for the petitioner has submitted that he may be allowed to approach the trial court to pay for regular bail. Stop. Prayer allowed. Bail, anticipated bail application stands closed.
Till then, Lordship, it may continue, Lordship. Till then. Gain my appearance, Lordship. My appearance. It may continue.
That is why we have observed that you were on anticipated, you were on interim protection.
That's it. Okay.
That'll do. They won't arrest. Now the charge sheet is something. Who's going to arrest you? Who will arrest you?
Obliged.
May I please, Lordship? Item number 5, Lordship.
Item 5. Huh?
We may be allowed to withdraw this bail application, Lordship.
Why?
Item number 5.
Why?
They have appeared already before the trial court, Lordship.
They appeared before the trial court.
Yes, Lordship.
Ms. Swenso, Learned Council appearing for the petitioner, has submitted that she is under instructions not to press this anticipated bail petition. Stop. Accordingly, this anticipated bail petition is closed as not pressed. Yes.
Listing of a bail application, Mr.
Why is it not? Why the mention is to be made for a bail petition? They are doing it on the next available date.
Means, vacation is there, so not sure.
So when do you want it?
27th.
Matters will be listed on 27. There will be a supplementary list. These are bail petitions. There is a notification saying that bail petitions cannot be kept pending if there are no objections, no filing objections.
Kindly.
Try it out. If it doesn't come up on the 27, make a mention. We'll take it up in the afternoon. On the same
Wait,
day.
please, your Lordship. Lordship, I beg to mention item number 19, Lordship. Can you pass
19?
over the matter for the day only, Lordship?
At the request of the Learned Council for the petitioner. List
Can it
this
be on
matter-
27, Lordship?
Not possible. 27, this last week of January
Yes,
up to 30th.
yes, Lord.
We have fixed more than 30 matters a day.
I'll leave it to
The
Lord.
regular bench will be, the regular list will suffer otherwise.
Possible for the day, Lordship.
No, we have to fix a date. We have to keep it on the 3rd of February or something. 3rd or 4th of February. At the request of the learned counsel for the petitioner, list this matter again on the 4th of February,
Maybe the
2026.
I'll leave.
I think 47.
Huh?
Abdomen, because service of the top number 2 is still evidence. Even after 1 week. Hold still.
Heard Mr. So-and-so, learned counsel for the petitioner. Records reveal that the service report on the respondent number 2 is yet awaited. List this matter again on the 10th of February 2026.
May please, your lordship, I beg to mention item number 44, my lord. I pray for adjournment, my lord. On CD's call for, perhaps CD is also not available, my lord. 44.
So in the earlier case, you write along with the service report, huh? On the earlier case, yes.
Yeah, item number 44, my lord. I pray for adjournment today, my lord, and perhaps CD is also not available, my lord.
Mr. So-and-so appears for the petitioner. Learned APP has submitted that the case diary is yet awaited. List this matter again on 5th of February 2026.
There is an interim for
The-
petitioner, my lord, that may be continued.
The interim protection granted to the the interim protection granted earlier shall continue.
Highly authorized.
Should put the card to item number 24. Final complaint has been submitted, Lordship. Charge sheet has been submitted on 19th of December 2025. This case number is 509 of 2025, Lordship. Lordship, LCR may be called.
LCR may be called for Lordship. Pending before the learned additional listing and session judge number 2, Lordship.
So learned counsel appearing for the petitioner, the learned counsel appearing for, you are for the NCB.
Lordship.
Learned standing counsel NCB has submitted that the final report,
Final complaint, charge sheet.
the matter has been charge sheeted. It is now pending before the
Learned additional listing and session judge number 2.
district
And session judge number 2.
District.
session judge number 2. Full stop. And call for the scan copy of the TCR. List again on 11th of February.
Most obliged.
May it please your lordship, I beg to mention item number 35, lordship. While the matter may be adjourned for 1 week, lordship, the senior is out of station, lordship.
At the request of the learned counsel for the petitioner, list this matter again on 6th of February 2026.
6 February.
35.
So the senior is not there, she will not be able to take a call. On the 6th of February, full stop. Learned APP has submitted that the charge sheet, that the matter has already been charge sheeted.
Lordship, interim.
The interim protection granted earlier shall continue till the next date of listing.
Obliged, lordship.
Letter for motion bail application, item 1.
Please, your lordship. Lordship, regular bail application, my lord. Petitioners are behind the bar since 51 days, my lord. My lord, at this stage, a CD may be called for.
Call for the CD. List again on 10th of February 2026.
Item 2.
That part you note down.
Yeah,
this
मतलब
application under
FIR
so and so
at 10
common रहता है ना? That I will not.
FIR at first 10, my lord.
हाँ.
The LS offense, my lord, 281, 324, 4, 132, 109, 35 of BNS, my lord. My lord, 281 is available, 324, 4 available, and my lord, 132 is not applicable, my lord, as per requirements of the FIR, my lord. And 109 also not applicable. And my lord, the co-accused already released on bail, my lord. I have annexed the order of and co-accused already released on bail on 16 days. But my lord, petitioner in custody 39 days, my lord.
Co-accused, the co-accused might have pushed and shoved. And your petitioner might have been the instrumental person in
No, my lord.
rushing to a,
No, actually, my
we
lord,
will not say about,
I have stated in paragraph 5, my lord, the petitioner was picked up by the main accused, accused number 1, my lord.
yes, sir.
After
Complaint is done. And then after seeing it, subsequently we will put this thing. If the person.
Page 14. Page 14,
Yes,
co-accused.
Yes. They released on only on 16 days in custody. Right now. 16 days. 39 days.
Huh? Page 16 and 17.
In condition, my lord.
Hmm? Yes. What do you say? Heard Mr. Swenson and counsel appearing for the petitioner also heard the learned APP. The learned counsel for the petitioner submitted that a co-accused who on a co-accused in the matter has been granted the privilege of bail in connection with the same incident and FIR. Drawing our attention to the aforesaid order, to the order dated 18/12/2025 passed in BA number 4019 of 2025. He has prayed that the present accused arrested may also be granted the privilege of bail. Full stop. Learned APP, though, has prayed that the updated CD may be called for, comma. It is observed that while granting bail to the co-accused, this court had already gone through the case diary, which was then produced, and had observed that there was sufficient progress in the investigation. And keeping in view the length of the detention, the co-accused was granted the privilege of bail. Full stop. In the present matter also, this court is of the opinion that although the conduct of the petitioners is despicable and condemnable, nevertheless, the present arrested co-accused may be granted the privilege of bail on the same terms and conditions which were imposed upon his co-accused by the order dated 18/12/2025. Accordingly, take down paragraph 11 and 12 from this one. 11, 12, 13, 14, and 17 and 18. Huh? In this bail application disposed. Done. January 40টা হলে 26টা হলে না জানুয়ারি মান নাই ফেব্রুয়ারি ঠিক আছে না না এতিয়া মই ধৰিছো 12-13 আগত নাযাওঁ 12-13 সুন্দৰ এইকেইটা কৰিব পাৰিছো
Item 3.
Maybe
Yes,
this is
yes.
also regular bail application. So petitioner is behind the bar for last 10 months, arrested on 22/3/2025, charge sheet case lordship. Lordship, charges under section 1031, murder lordship. And we have taken the plea of non-compliance of section 47 and 48 lordship. So lordship, at this stage, TCR along with the CD may be called for. Notice lordship may kindly see at page number 20 and 22.
20?
Page number lordship, 17. 5 copy. This is under 47.
Page number?
17, 17.
17.
These can be at best said to be lordship reason of arrest, not ground of arrest, lordship.
Weapon is recovered.
Weapon, not lordship, but that is the clear lordship copy paste from the forwarding report.
Huh.
Or nothing.
The
lordship.
forwarding comes later on.
Later on, lordship.
So it cannot be a copy paste of the forwarding.
But
Forwarding is a copy paste of this. Hmm?
lordship,
During the sufficient. The weapon is recovered with prior plan and full knowledge. You committed the crime.
no details
47,
about the
48.
offense, lordship. Examine lordship.
Other learned counsel for the petition, also the learned APP. Call for this scanned copy of the trial court records relating to
Session case number lordship.
sessions case number
81 within bracket
81
NL.
of
81 within bracket NL of 2025.
81/NL of 2025. List again on from the learned sessions also. 9th of February.
Lordship.
9th of February.
Lordship.
List again on 9th of February.
Honorable Supreme Court has held that it should be like that of framing charge, lordship. Those contents of the ground of arrest, lordship.
So the charge has to be framed even before the investigation starts.
That is the
So let us not go to that.
lordship, lordship.
It can be in that format,
Lordship.
telling you that yes, we arrested you on this part. We intercepted you on this date. You were carrying this X. There was blood on it. There was a murder. So you are arrested.
Here,
But
lordship,
that cannot be the charge. That cannot
only
be the
one line,
charge.
lordship.
Huh?
That X was recovered. That's
What more needs to be? Yes,
lordship. We'll see.
a man has died of X soon, and the X is with you.
Problem.
Not that. We'll have some other ground to discuss on the next date. Yeah, next. But the notice under 48 is something very.
May I please, my lord? My lord, this is charge sheeted case, my lord. Section 6 also is there, my lord.
Issue notice to the respondent number 2 under the prevalent notification. I'm not giving you the upper one. Who are paying. List again on 10th of February.
My lord, TCR message.
That all will come. Call for the
Okay.
TCR, huh?
Okay.
Call for the TCR.
Madam, 58.
Yes, please, your lordship. Lordship, charge sheet case, my lord, POCSO is there, man.
Same.
My lord, TCR along with CD, man.
TCR along with CD.
Please, man.
Madam, 4, most maybe.
Please, your lordship.
Yes.
The anticipatory bail application, we were granted interim protection, my lord, on 16/12/2024. Thereafter, we have appeared and cooperated, my lord. Now, case diary is also perhaps available.
Huh?
Case diary is also available, my lord. Wrongly come in the motion column, my lord.
Yes, already, today was granted on 16/12. City court.
Do we have that? No.
Here, there is a group around 7%. There is a dealing with the business of filling the oil from the railway train. And 2-3% arrested. He claimed when some police person saw he and the brother both are involved in
Family business.
That may also mention, but now I appear.
We'll make it absolute.
BUP maximum minimum 3 years for the father, subsequently involved than 5 years.
We'll make it absolute. Administration and council paying for the petition also heard the learned APP upon a perusal of the.
Yeah.
Huh?
SCDC.
Also heard Mr. KK Parasar, signing council.
Central Government Council.
Central Government Council. Heard Mr. K.K. Parashar, learned Central Government Council, who has prepared for the railways, full stop, for the RPF, full stop. The petitioner had been granted an interim protection on 16/12/2025, and the learned CGC submits that pursuant to the said protection, the petitioners have appeared and their statements have been recorded. Full stop. In such view of the matter, the interim protection granted earlier is hereby made absolute, subject to the same terms and conditions as noted in the
I'm deeply.
aforesaid order itself, please.
Deeply.
Item 6.
May please your lordship. Lordship, 482 application lordship.
Hmm.
FR is on page 17 lordship.
You are who?
Lordship, I am two petitioners lordship, two
Hmm.
brothers lordship.
Hmm.
One is named in the FIR, one is
Hmm.
not named in another is not named in the FIR lordship.
Hmm.
One elder brother and one younger brother lordship.
Hmm.
Lordship, allegation is of having meat and suspected meat lordship and having cattle in my home lordship. They were seized from my home lordship.
Could you account for the live cattle that was in your home? Did you have any documents?
Lordship, I have annexed, Lordship, receipts, Lordship, that is on Annexure 2,
Huh.
that is from page 25, Lordship. That is, I bought on 16th some of the cattle, Lordship. Thereafter, on 17th, Lordship, an FIR was registered and a raid was
Just
made in
a
my
minute.
home. But not all the kettles, Lordship. Not all the kettles I have. I have made some receipts that I have bought on 16th, Lordship.
Okay, we'll call for the CD.
Lordship, my elder brother may be protected at least, Lordship. Since he's not named, Lordship.
Let us understand it this way. Although this is not part of what we are going to record, but let us understand it this way. The criminals also, an alleged criminal also has to understand
Lordship.
that his one act may put other people in trouble also.
Lordship,
Call for the
possible,
CD,
Lordship,
list on
elder
12th.
brother, Lordship.
Huh?
His elder brother, Lordship, is not named.
Then why the two?
Lordship, one
It's
person is
another.
named, another,
Huh?
he is just living in his house, Lordship. He's the elder brother. He has nothing to do with anything.
But both are filing the application together.
Lordship,
Both are filing the application together.
together.
Then why one will make an allegation against the other?
Lordship,
We'll reject for the elder brother or
Lordship,
the younger brother. Whom should we reject for?
Lordship, it's
Since
protection.
your petitioners are making allegations against each other,
Not allegations, Lordship.
then
Uh,
who is this Amir Jan? Petition number 2 is the
yes,
elder
Lordship.
brother,
Petitioner number 2, Amit
and
Jahan.
petition number 1 is the younger brother.
Yes, Lord.
You are saying that the elder brother may be involved, the younger brother is not.
No, younger brother may be involved.
May be involved. So we'll reject it for 2 today, for one petition number 1 today itself.
Lordship,
Call for the CD for number 2.
Lordship,
Can we do that?
no.
No. Call for the
Lordship,
CD.
if
List
then
again on
thought it
12th.
may be given.
12th.
Obliged, Lord.
12th of February.
7.
Yes, sir.
Yes, sir. So I implicated in respect to one deferred case number 147 of 2021, Your Lordship. The section of IPC is attracted here, 341 and 376, Your Lordship. Lordship, let's only come to page 6.
Page?
Page 6.
Ah.
Your Lordship.
Seen the FIRs.
Yeah, this allegation is there, Your Lordship.
Huh?
Allegation is there, Your
Ah,
Lordship.
we read it.
FIR dated 9/3/2021.
Mm.
POSCO is there. And Lordship may kindly come to page 9.
So
the-
why something of 9/3/2021 is coming up now?
No, substitute case, they are not.
And Lordship may kindly send.
What is this? It's an AB 2021.
It is
Ah.
short. Notice was issued to me.
Ah,
I am not living in that place. Earlier I was living in that place in which the offence was being recorded. Now, Lordship may kindly come page 9. The FIR itself stated that on 6/3/2021, one incident was happening.
ah,
FIR lost 3 days after the incident, Your Lordship.
hmm.
And also, Lordship may kindly come to page 9. Page 9 is a basic thing, Your Lordship, to register any case, Your Lordship. That is clause 8, Your Lordship. Reason for delay in recording the complaint or the information, Your Lordship. That is completely silent, Your Lordship.
You are a named accused.
I am a name.
You are a name accused. 2021, the case was, the FIR was lodged.
Yeah.
Matter came to be charge sheeted. We are in 2026
Yes.
now. Today you have come for an anticipatory bail. The trial has been hanging because of your absence. Your address may have changed, but you knew about the matter. At this stage, should we entertain an anticipatory bail?
When the knowledge was there with the petitioner, then
He did not know, he did not know that there was a FIR against him.
I know.
He should have known. Then he waits for
Late-
4 years, and
late
now
enough
that he is
because
being searched out, he is.
Left for some job at Arunachal Pradesh because
Good enough.
communication gap was
Let him try it before the trial court.
and he get that protection, Your Lordship.
Let him try, let him appear before the trial court. Should we just direct you to appear before the trial court without a protection, or would you like to take the risk of
Giving the
appearing
protection
before?
only.
When is the
Yeah,
next
he's
date
going to
fixed?
appear, Your Lordship.
When is the next date
He's going to
fixed?
appear.
When is the next date fixed?
That is not being
Huh?
with me, Your Lordship.
Would you like to come back with all the details? We don't have the orders of the trial court. We'll ask for the scan copy. We'll wait for around 2-3 weeks.
Lordship will fix a date. Everybody, I'm not communicating, Your Lordship. Though
Huh?
I cannot mislead the court also because I do not know the next date, Your Lordship. Now, I will gather all the information and then I
You
can-
file an additional affidavit.
affidavit, Your Lordship.
Thereafter, we'll take up the matter.
Yes.
But Mr. Swansol, on counsel for the petitioner who has prayed that he may be allowed an opportunity to file an additional affidavit to bring on record the orders of the learned trial court, as well as learned trial court and other documents. Full stop. List again on.
Lordship may fix a date.
If we fix it, then we are fixing it on 16th. 16th of February.
It may be, if it is possible, 17.
Huh?
17 will be better.
17th.
17 to
17th of February.
deeply applied.
Please, Your Lordship. My lord, in this case, my lord, while transporting 20 numbers of cattle, my lord, in a vehicle, my lord, that was intercepted by the police, and subsequently, my lord, Hindu organizations has come, my lord, these, my lord, petitioners are drivers and handymen. They, my lord, escaped from the place, my lord, due to fear of moral policing, my lord. FI is at page 15, my lord. And my lord, the owner, who is the seller of the, my lord, cattle, my lord, Aminul Mia, he was arrested, my lord, immediately. Subsequently, he was released on bail. And the final purchaser, Nityananda Kaman.
Who are you?
My lord, we are drivers and handymen, my lord. We played well, my lord. We are on AB, my lord. Already, my lord, the final purchaser, he is also on interim bail, my lord. I have annexed at page 24, my lord. And this is the seller of the, he was also present in the vehicle, my lord. He was arrested. The Zimma of the vehicle is already given, my lord.
20 vehicles in one container.
It's a livestock paying vehicle, my lord.
Who loaded? Huh?
My lord, these are drivers and handymen. Actually,
Have you stated anywhere that 20 cattle can be taken up on that vehicle?
that I have not. But it is measured on weight, my lord. But my driver and handyman, my lord. That is why
The
I'm
person who loaded into the vehicle.
actually Aminul
Causing
Mia.
the trauma.
Well, Lordship, kindly come to page number 21. Aminul Mia, he was the seller. He loaded the vehicle, and these are the driver and handyman, my lord. And
They
vehicle
knew.
was hired.
They knew.
That is why, my lord. So driver and handyman, they may be, my lord. Otherwise, my lord, and my lord, seller is arrested, he is released on bail, and purchaser is on interim bail, my lord. Driver and handyman, my lord, they are daily wage earners, my lord. No, Aminul Mia, my lord, he was arrested, my lord. He was there, my lord. I placed the order of the bail, my lord. Aminul Mia, page 21, he is the seller.
And final purchaser was Nityananda Kaman, my lord. It is at page 21. He was to receive, my lord. Like that is. So when seller
is
was
this?
there, my lord, driver and
Who
handyman.
is Nityananda?
Nityananda Kaman, he is the final purchaser, buyer, my lord.
Uh,
He is a trader, my lord, cattle trader.
uh,
And my lord, seller was Aminul Mia. He loaded the, my lord, this.
he was granted the interim because he says,
Yes, final
I am
purchaser.
in no way connected to the
Yes,
transportation. It is just
transport
driver. And-
ultimately, my lord, Aminul Mia was directly involved, my lord. The driver and handyman, my lord, they may be, my lord, considered because they are daily wage earners, my lord.
Hmm.
That is why, my lord. Otherwise, driver and handyman, my lord. Actually,
And
they, on instruction of the, my lord, owner,
I will tell
they
you.
must have loaded, my lord. That is what. That is the driver and handyman, my lord. That is, and the owner of the vehicle was also arrested, my lord. It is reflected in the page, my lord. He was released on bail now, my lord. It is reflected in the page 24 order, my lord. My lord, owner of the, my lord, seller, who is the Aminul Mia, he is already released on bail, my lord. That is why I am praying, my lord, this driver and handyman, they are wage earners, my lord. Daily wage earners, they may be protected, my lord. Because
Heard Mr. Swainson, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, learned counsel appearing, learned APP. The counsel for the petitioner has submitted that the owner of the cattle and the final
purchaser.
purchaser
Hmm.
are on.
And the owner of the
Owner of the vehicle is on regular bail.
On
has
regular
been
bail.
granted the
Seller is
privilege of
also
regular
regular
bail, and the
purchaser.
final purchaser of the cattle are also on interim
Interim.
protection. Full stop. When is the next date fixed?
One is the driver with
The AB number 45 of 2026 relating to the final purchaser is next scheduled to be listed on 19 to 2026. Take this matter along with the aforesaid petition on which the CD has also been called for. 19 to
19.
in the interim it is provided that and in the interim it is provided that if the petitioners are arrested, they would be released on bail of rupees
Here it was on
10,000 each with with one surety of the like amount, subject to the satisfaction of the arresting authority. The petitioner shall appear before the IO within the next 7 days. List again on 19 along with AB number so and so.
highly available.
May I please? Lordship, I prayed that the maternity being taken after some time.
After some time, we say.
Next, listen. 482 obligation, my lord, FIR at phase 15, my lord. My lord,
What is it?
this is the Bandagular, my lord. Ezar Kari Anjuma Begum, 19 years. Daughter of Ali Akbar, so and so, my lord.
Where
Then, my
is the
lord,
English version? Something wrong with
my
that?
lord. English version, my lord, at phase 9. And actual fact is, my lord, the petitioner number 1 and the victim had a love affair. My lord. Accordingly, my lord, the guardian of both the parties, my lord, was sitting 2 times, my lord. I have stated in paragraph 6, my lord, page 5. On 18/11/2025 was sitting in the house of the victim, and again on 27/11/25 at the house of the accused petitioner, my lord. But subsequently, my lord, the fathers of the victim, my lord, declined to solemnize marriage, my lord, and under the influence of the father's my lord, the victim has lost the FIR, my lord.
Hmm.
And my lord, the exam of the petitioner number 1 is going on today, is also scheduled for exam, my lord, for BSc third year, my lord. BSc third semester, my lord, page 20 is the schedule, my lord. And my lord, petition number 1 and 2 is the elder brother of the accused number 1 and sister-in-law of the petitioner number 1, my lord.
We'll consider it for the accused number 1.
And 2 and 3, my lord, is
2
the,
and 3 we'll consider as and when the CD comes.
my lord, both, my lord, 2 and 3 also government.
Mr. Parashar, something which he has not argued but caught our attention. In the year 2022.
Yes, my lord.
So in the year 2022 would mean somewhere around 4 years ago.
3 years ago, my lord, as per averments of the FIR.
Do not speak when the court is speaking.
Sorry, my lord.
You would be digging your own grave.
Sorry, my lord.
Page 2. Age is 22 years. 4 years ago is borderlining 18. Maybe lesser. We'll ask them to appear.
Now,
See, had it been
the video is circulating.
A video circulation, it can be so many things. Retrieving from the phone of an old phone sold off, because you will not expect a person to retain a phone for 4 years as of today. If these are videos of 4 years ago, anything and everything could have happened. Let him appear. She was a minor or not is another issue. What about the accused number 1? He could have been a minor. Let the CD come, let his age be verified. Because if that happens, then if he was a minor, it's juvenile, nothing remains. Huh? Oh, we'll keep certain things in observation. And also, what is this you are showing? He also has his exams on his head.
Yes, my lord, page 20, 22 on 2026, my lord. First date, today, my lord.
Petitioner number 2 is a government servant.
Both, my lord, 2 and 3
Huh?
government servant. 2 and 3 both are government servant.
Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP, full stop. The FIR lodged on 812026 alleges an incident of about 4 years ago. Stating that when the informant was a minor, the petitioner had committed acts which would be punishable under the POCSO Act, full stop. The accused number 1 is a student who is now aged about 22 years, and accused number 2 and 3 are government servants. Full stop. There is a delay of about 4 years in lodging the complaint. Full stop. Call for the case diary. In the interim, it is provided that the petition number 1, 2, and 3 shall appear before the investigating officer. On or before the 28th of January 2026. Full stop. In the event of their arrest, they shall be released on bail of rupees 30,000 each. They shall be released on furnishing a bail of furnishing a bond of rupees 30,000 each with 2 sureties of the like amount. The privilege of pre-arrest bail shall also be subject to the following conditions. Number 1, they would not leave the jurisdiction. Number 2, they will not interact in any manner with the alleged the informant or her family. They will cooperate with the investigation list again on the 16th of February 2026.
I read one thing, my lord, informant is the party here, my lord, so notice may go to the
Hmm.
informant is met party. Since the POXO is there, my lord.
Oh, yes, that problem will remain. I did not notice that. Without notice to the informant, can we grant the,
That's why, my lord.
but then what about his exams and the delay?
Very well, my lord.
Hmm.
FIR of 2nd of January. Till now not yet.
So it becomes difficult. But this would be, this does not appear to be a very Will issue notice granting the interim and liberty to pray for cancellation. Is it not? Otherwise, two government servants and one student 4 years ago, someone now wakes up because there is a clause of law. Huh? So, issue notice to the respondent number 2. Issue notice to the respondent number 2 under the prevalent notification. Full stop. It is made clear that only on the ground that the petitioner number 1 is a student who's slated to be appearing for his examination, and the two petitioners are government servant, and the delay in the lodging of the FIR has urged this court to grant the privilege of an interim pre-arrest bail. Full stop. The respondent number 2 shall be at liberty to pray for cancellation of the bail on her appearance before the before this court. List again on. Keep a short date 9th. On 9th. On 9th.
Obliged.
Adjourn 59.
Yes.
The petitioner here is a constable of Assam Police, my lord. He
Hmm.
is over 28 years.
Hmm.
And the complainant is a 21 years girl, my lord. They were in love.
Hmm.
Ultimately, it broke down. And therefore, the FIR had been lost. And there was a allegation is that in 2024, my lord, January, he will marry him, my lord. But now in undated FIR has been lost and it had registered on 13/1/2025, my lord. What you'll find the FIR in page number 14, my lord. Allegation is that there is a promise and there is no marriage has taken place, my lord. That's all, my lord. We'll cooperate with them with the police constable, my lord.
Allowing the interim. Heard Mr. Swanson and counsel appearing for the petition also heard the learned APP. The learned counsel for the petitioner has drawn attention of this court to the fact that the FIR is undated but registered on
13/1.
13/1/2026 regarding an allegation of the year
Nowadays.
2024. Huh? Hmm.
10 years.
Unions is there, but
Hmm.
that is the
In earlier occasion, say like nowadays, it is taken seriously.
What the promise to marriage? What we are on is that 24, she should have come in 25 saying he's not marrying me. Stop. Call for the case diary. In the interim, it is provided that the petitioner will appear before the investigating authority on or before 30th of January 2nd of February 2026. In the interim, in the event of his arrest, 10,000 two sureties of the like amount. List again on the 16th of February 2026 along with the case diary.
For admission, remember,
16th.
I can 11 for admission.
Yes, madam.
Your Lordship, petitioner, who happened to be the
Mm,
officer in charge of the police station,
mm,
he was, while doing his official duty,
mm,
he lodged an affair against the uh, present respondent number 2, Lordship,
mm.
and subsequently doing all formalities as required by law. He filed, FIR was filed,
Mm.
and pursuant to that FIR, Lordship, the respondent number 2 brought before the police station, interrogated.
Mm.
Thereafter, Jimmanama was executed.
Mm.
After obtaining the Jimmanama, he was released.
Mm.
And after getting released from that case, Lordship, he went to the court and filed a complaint projecting a case where this petitioner arrayed as respondent number, accused number, just a moment.
Where is
Eight.
that?
Eight,
Where is the
Lordship.
complaint?
Yes, accused number 8.
Where is the complaint?
Complaint is at page, starts from page 31.
Allegations
Page
against you?
31, serial number, Lordship would be pleased to find his name at page 32. Dipjyoti Malakar.
You are a complaint, you are number 8.
Yes. I was at that point of time, I was acting as an officer in charge of the police station of Nilambadar police station, Lordship. So, and this is the complaint, Lordship. Lordship, may
I've got it then.
read the contents of the affair, complaint.
We have seen that part. Yes, then.
So, this complaint has been, so basically, given, Lordship, that whatever I was doing on my official capacity. And so the Lane Trial Court ought to have received the prosecution sanction, and without prosecution sanction, Lordship, initiation of this proceeding itself vitiate the proceeding, Lordship. So there is no 197 sanction as required by law. That is the whole crux of the gist of the matters. And Lordship,
Prosecution sanction is your only ground?
that apart, nothing, the record will reveal that, yes, of course, Lordship, that is the basic ground.
Yes. You are appealing for?
Lordship, the order was passed on 21/7/2022. Your Lordship, kindly see the page number 47. It will stated there. The complainant was no is connected with his official duty at that moment. And the
Who was not connected with the official duties at any point? Petitioner.
Yeah. Petitioner. So sanction is not required.
Sanction is not required.
Yes.
Okay.
The chop of the was at the police station by the state. And top of the only the passerby it was no connected with the, and they just take it to the foot station.
Hmm.
And written in
Who is Rupak Das is the person?
Rupak Das is the complainant.
Hmm.
And Champak Das is the party.
Lordship, I may be allowed to place the brief, Lordship. Here. In this.
Yes,
complaint,
Mr.
Lordship,
Parashar, have you, Mr. Goswami, have you gone through the petition? The only point to be decided is whether it was in the course of discharge of official duties. If so, for criminal prosecution, you would require sanction. If it is beyond official duties, you don't need the sanction. Simple case. Pending from 2022, original records of the trial court are here. Without a stay, everything is a stayed. Either we allow it or we disallow it. When? That is the only thing we have to decide whether
only thing, Lordship.
whether there is some semblance of the discharge of official duties
Duty.
when the act was committed. If it is there, they would have to ask for a sanction. The trial court has considered this aspect of the matter. Just let us, where is it?
May I pray, Lordship, at this stage?
It is
Maybe.
at page 49 of the petition, if you have it. With regard to the accused person, namely so and so.
Yes.
You see that part was considered. Then why the court holds that it is not a, that sanction is not required is discussed thereafter, and we don't like to keep this pending. Page 60. Page 60, last paragraph, after taking into account all the aforesaid discussion as a whole.
They are totally uncovered with their official duty and not in connection with their official.
Just above
It's
that.
not required for. Is not required for.
He has come to a conclusion. Prior to that, the learned trial court holds that during the trial, he will have ample opportunity to see that it was to show that it was in the discharge of official duties. That can be a defense. But for the purpose of starting the trial, the sanction will not be necessary. That is what the court. Let's find out the law on that. When?
Lordship, next month, any day, after 20, Lordship.
After 20?
Yeah.
Heard the learned counsel appearing for the parties. Also heard the learned APP. Admit the petition. List again on
25th, Lordship.
25th.
25th of February.
25th of February 2026 for hearing.
There is an interim order operating in this case, Lordship.
Where is it? What date?
Interim order is there, Lordship.
Yes, what is the interim order?
That it's been
Sorry?
it's been
Interim order, the interim order passed on the interim order. Keeping the further proceeding in CR case number 888 of 2022 pending in the court of Learned Chief Judicial Magistrate Karimganj by the order dated 13/12/2024 shall remain in force till the next date fixed.
I'm deeply oppressed.
On 26th. 26th. Thursday.
Item 12.
May I please, your lordship?
Hmm.
Lordship, in this case, lordship, on earlier occasion, lordship, the honorable court suggested us to convince our client to compromise this amicably, lordship. But this amicable settlement was not, lordship, happened,
Hmm.
lordship.
Hmm.
Now, lordship, the petitioner will contest this case, lordship.
We'll admit it, take it up on the 25th, 26th. 26th of February for disposal, huh? Or you want to do it today?
Otherwise, ready, lordship.
Ready?
It will take some time, lordship, if,
Huh.
lordship.
We have all the time in the world.
Because he will take time, because it is operating.
Hmm.
On the last occasion, if your lordship kindly see the orders from 2/9/2025.
Hmm.
Another set of advocates, so your lordship.
Yes, lordship.
Ah.
They took time, lordship, continuously on the last day also, lordship, they were none here.
Hmm.
In this, your lordship, they are taking this.
Lordship, what happened, lordship, the client, lordship, returned back this file from me, lordship, and again contacted with me to contest on his favor, lordship. Earlier, lordship, he returned back the file, lordship, when the compromise matter was going on, lordship.
He was earlier, lordship, advocate.
Yes, lordship.
Subsequently, two advocates came. Again, lordship, today, the earlier advocate.
Yes, lordship.
We are taking that.
Someone may someday approach you also.
Your lordship, if the lordship last of.
We'll have it on the 20th. No, it is not about a question of last opportunity. We are admitting it. We are fixing it on the 26th of February for disposal.
Lordship. Lordship.
Heard the learned counsel for the parties. Admit the petition. List again on 26th of February 2026 for disposal. Admitted. It is already admitted. Yes, do not conduct our proceedings for us.
Otherwise, if it is come for hearing proceed, may not this and that matter will go for another. 10 years. Because the legal matters are hearing matter, your lordship is that. So as an admission matter.
Make a mention for upgradation on that day if necessary. And if we do not conduct this conversation in the court, if we do not take our time in this kind of conversations, most of the courts, including us, have been finishing our cause list and waiting for a hearing matter. And hearing matters have been disposed of. Even yesterday, we have disposed of 2. When 5 were listed for hearing. Day before yesterday, we disposed of 4. When 7 were listed for hearing. Let me assure you, we are doing our best. You will not wait for the next 30 years. Yes.
Back legal lordship.
Hmm.
Also, kindly see the last order. Accordingly, the respondent wife has appeared.
For the respondent.
Hmm. Yes, another 10,000 paid.
Yes, ma'am, I have paid and she has received now.
Huh.
They are challenging the
Huh?
they are challenging the order of the Garnet family court also.
Huh.
Also, I am going on living income, I have 2 children, and they are also studying. So if this order will be spared, the very object of maintenance will be repeated also at this point of time.
What was the
The order dated 19/7/2025.
Why are we aggrieved by that amount? What was the amount granted?
Yes, my lord.
What was the amount granted?
The learned trial court granted to the extent of amount of rupees 9,000 per month.
Hmm.
Yes.
From the date of the filing of the case.
Hmm.
So as per before institutions of this case, I have regularly paid rupees 3,000.
Hmm.
Subsequently, and whatever maybe I have earned, I have given to my wife and to my children. Subsequently, she filed in 125 proceedings, and at that proceedings, the learned trial court give a direction to me to pay an amount of rupees 3,000. And accordingly, without I have been failed, till today, I have paid the said amount. And lastly, your honor, sorry, your lordship has give direction to me to pay an amount of rupees 10,000. So at my best, I have paid 10,000 rupees without any delay to pay it. But now the question here is that the learned trial court pass an order to the amount, to the extent of rupees 9,000. It is, I was unable to pay that rupees. Because my lord, first of all, if your lordship kindly see, the learned trial court passed the said order that there is a judgment, that is the Rajnesh versus Neha, where the Honorable Apex Court has clearly stated that before going to passing an maintenance award, the learned trial court must go the assets and liabilities and other facts and circumstances of the case. The learned trial court, while passing this amount of to the extent of rupees 9,000, my lord, the learned trial court without going to my income. Here the issue is that.
What is your stated income now?
Now I have clearly stated as per your lordship, kindly see. That is your interim order, lordship, kindly see page number 19 and 20.
This is the order under challenge?
No, that is interim order. At that time, my lord, I was earned rupees 12,000 per month. On the strength of the said earnings, the learned trial court passed to give an direction to me to pay an amount of rupees 3,000. At that moment, for a moment, if your lordship kindly see that at that moment, I have received the rupees 12,000. And accordingly, I have paid rupees 3,000, my lord, as per direction of the court. Now, your lordship kindly see the assets and liabilities your.
Assets and liabilities.
Is already, you have already filed it.
Yes, my lord.
You have already given it. It is before the family court.
Yes.
Yes, my lord.
Huh.
Now the question here is that I have not any hesitation to pay rupees 3,000, but the amount has been to the extent of rupees 9,000, my lord. The final order, I have challenging the final order, my lord.
This does not refer to the. Huh.
Monthly income.
So after that was after deduction, my lord.
Where
So
is it?
whatever I have earned, that monthly income, that was I have earned. There is a, my lord. I have annexed that document, my lord.
7,423 is his net salary. And he's supposed to, and he's supposed to pay you 9,000 per month.
Lordship may appreciate one thing.
So my lord, there is a bike.
During the pendency of the maintenance case, he has procured 2 loans.
That is also
2 loans, and also he has purchased.
Now that we will leave to his headache. Kindly tell us that if we.
Lordship self-created liabilities cannot deny the ground to maintain.
No. We are saying that his monthly income is 7,423.
As per his.
Net salary, which you perhaps did not.
He is also working in a school, my lord. He is also working in a
Where
school.
is your asset and liability?
So there is their petition, Lordship.
I am asking about you. I am asking
Lordship
about
will
you.
file, I will reply.
When?
Okay, my lord. Then give an opportunity to him to file their petition. So this is crystal clear, my lord. See, as per my lord is awarded 106 of the Indian evidence, the burden of cast.
No, we are giving this long hearing only because we want to dispose this of today.
So there is EMI.
You
also
did not submit your asset and liabilities?
in the trial court.
In the trial court.
Huh. Where is it?
After appreciating all the evidence, this is their petition, they have not annexed here.
Probably, my lord, there is an.
You are appearing for the first time in the matter.
Yes. We pay for-
So today we have to consider the interim, yes.
That's it.
We'll have to consider the interim today, that is the order.
Not at this point of time, let me file my reply. Not at the very object of matter and very.
Heard Mr. Esra Malada, counsel appearing for the petitioner, also heard.
Answer.
Mr. So-and-so, counsel appearing for the respondent number 2, comma, respondent number? For the sole respondent, comma, who has prayed for some time to have his instructions and file the affidavit in opposition. Full stop. By the last order dated 22/1/2026, this court had observed that the consideration of the interim order shall be made today. Full stop. However, on the prayer of the learned counsel appearing for the sole respondent, comma, the consideration is kept open for the next date fixed, that is on the 16th of, on the 16th of February 2026, full stop. The respondent would be at liberty to file their response prior to 16/2/2026 with advance copy to the counsel for the petitioner. Interim, a prayer for interim protection will be granted, will be decided on the next date.
Deeply obliged, my lord.
Yes.
May I please, Your Lordship? My lord, this petition is filed for quashing the inter proceeding of a special P case arising out of Sail Mary's, my lord. At the time of Mary's, my lord, she was 15 years, 8 months, 16 days. And petitioner is the husband and the, my lord, victim is the wife. Lordship, my lord, already settled some cases in this respect.
Yes.
And she is.
Husband, wife.
My lord.
I've not gone through the.
2 o'clock. 2 o'clock. 2 o'clock. 2 o'clock.
My lord.
If he
Yeah,
cannot
my-
find a good reason,
My lord.
yes, next duta baje.
Items 15.
May I please, the Lordship. Lordship, in this case, Lordship, in the last occasions, Lordship, Lordship, kindly see the last order, Lordship. And my learned friend, Lordship, Bankim Sharma, last night and today morning also informed, Lordship, instruction has not been received.
Huh?
Hospital, Lordship. He already informed me, Lordship, that no report, instruction has been received. And Lordship, in this case, Lordship, since 8 years back, Lordship, my vehicle has been seized. Lordship, I have given a judgment, Lordship, FX court judgment. There is a long pending investigation. It is a ground of washing. And Lordship.
Washing of what?
Lordship, washing for criminal side, Lordship. Whatever criminal proceeding is there. I am now, Lordship, I am paying for washing. As because, Lordship, this is the petty offense. And Lordship, this state government's notification is there. I have annexed. Lordship, pursuant to that notifications, my case is covered and similar case is already withdrawn and that vehicle has been released. I have annexed this order sheet, Lordship. So that's why, Lordship, my limited submissions, Lordship. 8 years gone, Lordship. Lordship, in fact of the case is that, Lordship, that one track has been seized. My track has been seized in the year 2018. Ultimately, a confiscating proceeding has been drawn. And that confiscated this.
The notification gives the liberty to the APP to pray for that withdrawal of the case, na?
Lordship, here in this case, what happened, Lordship,
in his absence, should we decide it?
Lordship, then Lordship, if my humble request with hold hand, Lordship, kindly maybe fixed on very short next week, Lordship. Otherwise, Lordship, I'm so much sufferer, Lordship. My vehicle has been already damaged.
From 2018, you have come now.
No, Lordship, why I am coming now, Lordship? That Lordship, notification.
So accommodate the court for 2 weeks. We'll have it on 16th. Huh? 16th.
Lordship, if possible, 9, Lordship, 9.
9.
If possible, Lordship.
9th. A prayer has been made on behalf of the learned special PP Forest for an accommodation for today. List again on the 9th of February 2026.
Lordship, 1.
The learned special PP shall be at Liberty 2. Or do you say that no report has come?
No. Lordship, here my learned friend has informed me, Lordship, that he has some confusions. Yeah. Lordship, last night he already told me some confusion is there, Lordship. He's saying, Lordship, whatever as per the last order, the instruction has sought with why this case has not been withdrawn. But here in my case, Lordship, till date, no offense report or charge sheet has been submitted. So that's why.
Learned counsel for the petitioner submits that no offense report has been submitted till date.
Till date.
Till date, full stop.
Lordship. That's why, Lordship, in the first date, Lordship, report has been called that what is the status of the presently, what is the status of this case number is showing.
We'll decide it on the 16th. We'll decide. এখন কি হয়?
And same another case, Lordship, analogous case.
For both the cases, item 15 and 16. List again on 16 too.
I leave this.
There's something.
Supplementary section number 16.
Oh, that's it.
May I please, Lordship? Well, in this case, my lord, the substances were, my lord, allegedly found in a vast, Lordship. They are not recovered from the position, my lord, physical position of the petitioner's Lordship. 3 persons were arrested, my lord. No passenger was interrogated by the IO Lordship. Only the, my lord, handyman and the drivers were examined, Lordship. My lord, they also could not, my lord, establish that the physical position of the substances were.
Yes, sir. That is what I think.
That case,
When was it last listed? I remember this case. 21. What we were asking of you is material has been recovered from a bus. Driver and handyman are there. We do not know whether there are any other passengers or not.
PW1 and you said that both the persons in the bus with the brakes in there, one kept under the seat, one kept subsequently when taking at the time of taking the inspector all the passengers go down from the bus with the brakes. These 2 passengers without their brakes and subsequently these brakes as per the handlers of the PW1.
Will require some hearing, sir.
Lordship.
It will require some hearing.
This stage it may be admitted, we may be released, directed to be released on bail, Lordship.
No,
Suspended.
If the evidence had been to some extent.
Yes, kindly see, Lordship, PW1.
Yes, PW1.
PW1, kindly see. Cross-examination.
20 kgs of cannabis, huh?
For the sake of time, Lordship, I am coming to the, my lord, cross-examination, Lordship. Lordship, cross-examination, PW1, handyman, Lordship, married, Lordship. It is the fact that that after recovery of the contraband from the alleged accused persons, police kept the contraband in the bags and apprehended the accused persons and kept both the accused persons and the bags in the police vehicle and took the bags along with the accused persons to the police station. It is a fact that I do not have any ID in order to prove that I am the handyman of the said vehicle. It is a fact that I do not have any proof to assure my attendance at the bus counter or in the bus on that very day. It is a fact that I do not know who have kept these two bags under the seats and bunker of the vehicle out of these two accused persons who were seated on seat number 5 and 6. They don't know, Lordship. It is a fact that there was no bag in possession of Muhammad Rakesh Hussain when he boarded the bus. It is a fact that I do not know the seat number of Muhammad Rakesh. It is a fact that the informant was not present at the place of occurrence when police signaled to stop the bus and recovered the suspected contraband. It is a fact that police had not recovered anything from the physical possession of these three accused persons. It is a fact that there were about 15 passengers.
How
and
does
five
any of
seven-
this help you? Except Rakesh Hussain. He was without a bag.
Well, it is a fact that police had not recovered anything from the physical possession of these three accused persons. Physical possession, Lordship. Yes, physical possession must be. My lord, otherwise, my lord, there should be, my lord, there should be, my lord, specific evidence, Lordship. My lord, he says, he cannot say hose bag, which was hose bag. How he can say this bag were kept by the passengers, Lordship? It is a
A3 has
fact
been
that there
acquitted.
were about 15 passengers.
A3 has been acquitted.
One was acquitted, Lordship.
A3 was acquitted. Rakesh was acquitted.
Rakesh was acquitted.
We'll admit it, take it up for hearing on your. You have read the cross-examination, but the part which has not gone unrebutted is after sitting on the seat number 5 and 6, both the accused person kept one of the bags under their seats and another bag in the bunker.
Now, well, he cannot show that he was on that very day.
The handyman of that bus.
Handyman, Lordship.
Oh, where did
No
you ask
ID,
him?
nothing is there, Lordship.
Where did you ask
No.
him?
Maybe, my lord, those two persons, my lord, are accused, Lordship.
We'll have it
They
in.
were not accused.
We will have it.
My lord,
We will-
interesting, Lordship. What
we-
I am submitting, Lordship. Interestingly, my lord, the person who signaled the bus, police constable, Lordship, he has not been examined. He sees the.
We are not deciding the appeal, sir. We are deciding whether we should consider
the
a
purpose of
bail.
deciding
Whether we are considering whether we can consider your bail today or not.
Lordship.
To the mind of this court, we can hear this matter in the first week of March.
For final dismissal, Lordship.
Decide your acquittal or your upholding the judgment.
That may be fixed, Lordship.
We'll fix your date, please.
Huh?
5th of March.
Lordship.
Trial court records heard Mr. So-and-so, also heard the alleged APP. Trial court records have been received. On a perusal of the trial court records, this court is of the opinion that the matter may be listed on the 5th of March 2026 for final disposal.
Oblige, Lordship.
May I please, Your Honor? Your Honor, matter may be adjourned for today, Your Honor, because my senior is out of district. He is about
Request of the learned counsel for the petitioner, list this matter again on
28th maybe.
not this month. 9th of February.
No, Your Honor, please, Your Honor, short date may be given, Your Honor.
6th of February.
Okay, Your Honor.
6th of February.
Okay, Your Honor. Oblige.
Item 20.
It's a substitute matter, Your Honor.
Yes, sir.
This is case number 87 of 2025.
You have received copies, madam? You have received copies of the. Yes.
He was arrested, your lordship, in connection with the business case number so and so, your lordship, 215 days behind the bar, your lordship. At 37 days, to complain victim. And also, victim and complaint was examined. your lordship. Examined good. Victim and complaint was examined, your lordship.
Victim has been examined.
Examined. Service division,
Yes, madam, what do you have to say?
Am I correct?
Huh.
Examination.
So, at this stage, either we call for an updated, we'll call for the updated.
Also, sometimes
Once
they
you-
lost after 5 months, or whatever maybe. Pregnancy was after 5 months of the effort. Oh, what is maybe?
After 15 years only, and there was ship continuous race, and thereafter ship did 5 months. 5 months. Then only the.
Yes, madam. Otherwise, it is possible 6, madam. 6.
Await service report list again on the 12th. 12th of February.
12th of February, madam. Deeply aware.
2026.
Madam, 22.
One of my friend was here, my lord. One of my friend was here. He went to the washroom, my lord. So kindly time being easy.
We would like to remind you that you are on live. Yes. NDP.
Your lordship, on the earlier date, I had given a best to convince this honorable court, but I was pending with certain judgments of the honorable apex court as well as honorable high courts of the country. So I am here with the if your lordship is little well versed with the facts, I may proceed further. May I please?
No, I tend to forget what has happened. A little.
Oblige, your lordship. Actually, I was detained on a Naka checking by police from some reliable information that I am carrying contraband substances. Thereafter, police arrived, put up the checking, they got the substance. They seized the substance from me, they took the police station. I was detained. Upon my confession, as per the FIR, another person was arrested, and then investigation was continuing. In the meanwhile, police filed the charge sheet. And therefore, I had come before this honorable court for bail. Regular bail. This is the brief, your lordship.
And what
So,
is
now your lordships coming to the point, my first ground for today's argument is my detention was beyond 24 hours. From the time of detaining me to the time of producing me before the learned magistrate below.
Okay.
So for that, I have DK Basu versus State of West Bengal, 1997 1 SCC 416, which categorically states that the delay in formally recording the arrest within the time and production before the magistrate rendered the petitioner's arrest in violation of the procedure established by law.
Okay.
I was, as per the FIR, I was arrested on 17/6/25 at around 11:30 AM. I was detained. Then, as per the section 47 notice, BNS notice, which is in annexure to the additional affidavit which I have filed.
Where do I find that you were detained?
May
11?
please, your lordship, I couldn't get it.
Just a minute. You were detained in between 11:15 and 2:20.
Yes, Your Lordship.
11:15 they
exact-
start the NACA proceedings and they all came back at 2:20. So sometime in between 11:15 and 2:20. Okay. And
Then, as per the section 47 notice, my date and time of arrest is 18/6/25 at 12:30 p.m. And Your Lordship, the most interesting part here, as per the FIR, I was produced before the magistrate at 3:33 p.m. on 18/6. Then again in the FIR, they have clearly mentioned date from 17/6 I have arrested, means lodging of the FIR, time is from 10:45 hours. AM, PM, nothing has been mentioned there.
10:45, if you say 10:45.
Yeah, if we consider the 24-hour clock, then it's in the morning, Your Lordship. I agree to that point.
Yes. See if you come to page 12, we'll take it up at 2. You go through the records, you do whatever you want. If you come to page 12, second paragraph, at 11:15 a.m., this is when the NACA is set up. Done? Then if you come to page 13, after completion of all formalities paragraph, I along with the staff apprehended person departed from PO at 2:20. So the apprehension is between 11:15 and 2:20 on 17/6. He is into your custody now. Additional affidavit, page 39. Police station so and so, date and time of arrest 18/6/2025 at 12:30. 11:15, search 2 hours. From 2 o'clock it goes back to 12. From 12 to 12:30 on the next day he is under illegal detention. All matter of record. Yesterday we were discussing a Pamidi case. I had delivered there we have discussed this part. The production is after 24 hours of detention. What to do? What to do now? Go through the records at 2.
At 2.
At 2. This is the only ground we can go.
I have more 2 grounds.
Does it require an adjudication, those 2 grounds? Yes.
At 2, Your Lordship.
What is the ground? Just one-liners.
The second one is non-compliance of section 36 notice.
Okay. And
the third one is, Your Lordship, little technical, but the investigating officer has filed an extension petition for extending the period of investigation on 18 December 2025. Sorry, 8 December 2025. But the period of 180 days was to expire on 13 December. Then on 8 December, the learned trial court below rejected the petition on several grounds. I have the annexure. I will come to the point. But on 9th of December, the IO has filed the charge sheet. Now, there are little anomalies which I would like to bring at to.
Otherwise, for the purpose of this bail application, if your detention becomes illegal because of the 24 hours gap, the rest of it you can argue.
And thank you so much. Deeply.
At 2, huh? At 2 ভিতর দিব, huh?
Item 23.
My pleasure.
Yes, sir.
Regular bail application, the search is the bail. Was arrested on 28/5/2025. Adjourned at 240 days in custody. First, Your Lordship will find the FIR at page 13 minutes. The case of sexual harassment of a minor, Miller.
Recorded.
Yes, Miller. I have also furnished that 164 statement, Miller. That now 183, Miller. Page 24 is the 183 statement of that. Evidence of the victim also is at page 34, Miller. little contradiction, my lord, in the 164 statement, she stated that she was, that grandmother was with her. And she was a drunken state, therefore she could not resist.
Who was in a drunken state?
That mother, grandmother.
Okay.
Grandmother.
Hmm.
And in the evidence, he said that grandmother was out of the group at that time. And the medical evidence stated nothing against that, no such evidence of sexual harassment. Out of 6 related.
Produces certified copies of the evidence recorded up to date.
Publish.
No, 25.
May I please, Your Lord? My lord, regular bail application, my lord, intermediate quality quantity 20B. Already 48 days in custody, my lord, 2.7 kg ganja recovered. So 60.
And last date on 31 place for production, so something not done yet. And submitted.
ECI is
Then dispose of, my lord.
charge sheet.
I will.
Huh?
I will approach the trial court.
The trial court records reveal that the charge sheet has been submitted in the case. Mr. So-and-so, learned counsel appearing for the petitioner has submitted that he may be granted the liberty to approach the learned trial court to pay for regular bail. Stop. Prayer made is allowed. The bail application is closed, allowing the petitioner the liberty to approach the learned trial court to pay for regular bail, comma, which application shall be considered by the learned trial court on its own merits without reference to the closure of this bail petition.
Oblige.
26.
Bail application disposed of.
Make your lordship, my lord.
Ah.
The Procedural 2 is there, my lord. And they are in custody for more than 5 months now, my lord. Total 8 petitioners, almost all of them family members. And charge sheet filed on 11/11/25. Till today, no other progress, my lord. This was called initially on 19/12/21. Then, sorry, 25.
This is a bail application 4137.
Yes, 4137. 4137.
There is all, what is the? Okay. There are already some bill, anticipated bill petitions rejected. And a criminal petition is also pending with the same FIR.
Same FIR means other person might have filed, my lord. We are not, huh?
24 accused, we are 8.
Total 24 accused, my lord, we are 8 person before lordship. All of them are family members almost, my lord, except 1 or 2, my lord. I am not married at this stage, my lord, only because your lordship kindly see page, that is only gown page, my lord, 48 and 47 gowns only, my lord. Page 63. Last time your lordship has seen that, my lord. Page 63 and page 79.
Page 53.
66. These are the gowns, my your lordship kindly see in both same gowns, same, yeah, that you have been arrested as you have conspired murder and assault of the victims. Who are the victim? What is their murder? This is not the law, but it says just one decision, Ahmad Mansoor, man.
Yes, sir. Is it ground enough?
No, that
is one aspect of the matter. If this 47 notices what it appears to be here.
Yeah.
All this
79
47 notice.
thing.
You have been arrested as you have conspired murder and assault the victim.
Who are the victim? You have been arrested as you are directly involved with this case. What is the case? Paragraph 48, my lord. Paragraph 48.
If this is given to the parent or the relative of the accused, arrested, would he understand anything? Or does the even arrested understand anything?
Okay.
Yes, madam, you are appearing for?
Yes, 4879, page 79.
Applicant, no, informant.
This section does not give the right to report this.
Why so? You are doing two things. You are first, you are admitting that the section 47 has not been complied with. Huh? You'd like to go through it. Now you are making two statements. One, 47 has not been complied with. Secondly, against the Supreme Court, even non-compliance will not lead to a bail. Yes, Mr. Goswami?
Yes, he has been arrested as he has conspired in the part and assault the victim.
Of the victim.
Second one, he has been arrested, he has directly involved with this case as first statement.
Independent witness. Now, which is the murder? Who has been murdered? Who is the victim? Assault with what?
Not sufficient, but
If it is not sufficient,
There is no part, my lord.
each of the notice is insufficient, which are being for which the persons are going out. It is only because the case is not of one of no notice. The case is one of insufficient notice. Always.
Page 79 is the 48, my lord. Page 79.
I'll say it will be the same language.
Same,
It has to be the same language.
Same language, my lord.
So even if we say that the arrested accused may have known, 79 again come, page 79 will come in then. Relatives or friends or family has not been given enough notice. Grounds of arrest, simultaneous grounds
5
of
months,
arrest
my lord.
must convey the arrested accused all basic facts. Murder and what? Conspiracy and conspiracy in the murder of so and so on so and so date. Enough, perhaps, for us to hold. In a murder. In which murder? আপুনি ভুক্তভোগীৰ হত্যাকাণ্ডৰ ষড়যন্ত্ৰ কৰা অনুসৰি গ্ৰেপ্তাৰ কৰা হৈছে। ভুক্তভোগীটো কোন?
আৰু independent witness ৰ victim.
ইণ্ডিপেণ্ডেণ্ট উইটনেছে কৈছে। Your case would not suffer, the trial will not suffer, but the arrest being wrong. You want to go through the records?
Yes.
Otherwise, sir, case taken. He wants to go through it.
We have, I'm not on the merit, my lord.
Otherwise, we are not.
Yes, but I am not on the.
Otherwise, we are not
I'm
there.
not at all on merit, my.
47, 48 notice not
Yes,
enough.
only on that one.
Show us something, if there is something on record to show that they had knowledge of the. It was at 2? Huh? At 2 we'll have it, sir. Look.
I don't see one.
So him here. Have you filed the affidavit? No. Then why for the time being? Take time to file the affidavit. You get to. At 2.
Please, Your Lordship.
Yes.
Lordship, may possible for the timing as engaged counsel is on leg.
Huh?
Possible for the timing.
Mr. You had taken some time on the other day. For what? Huh? No. You had taken time on the last occasion, Mr. Goswami. Yesterday, it had come up yesterday, perhaps. Abo, after two, at two, no, head after two.
May I please, Your Lordship? Lordship, it's a case of pure misuse of the POXO provision. So they are 3-0, my lord, if possible.
3-0. বহুত আছে। Sixth.
My lord.
Sixth, you received the CD, huh? Sir, we may copy today itself.
I'll do that.
List again on 30 January 2026. Mr. So-and-so enters appearance on behalf of the respondent number 2. Ms. So-and-so is present as the amicus. Sixth.
What's already?
Item 64.
Your lordship, kindly, your lordship would have 22-0.
Hmm.
From that day, matter is one, but today it was only approved at my room. It was good this morning, my.
There's no difficulty. We have just given the liberty. Anybody can approach the jail
Yes, but
authorities and all the.
But we could not hand over because today it is just approved. It was closed. And otherwise, matter 62 days, my lord. 90 days statutory period, my lord. And ultimately, family almost my lord, cousin, sister, my lord. On merit also, your lordship. Yes. Na service to naam to diya nahi. But your service complete already appeared, my.
Service report on. How do we say service card? Service completed?
I have the.
Heard Mr. H.I. Chaudhary, Learned Counsel appearing, Senior Counsel assisted by Mr. So-and-so, Learned Counsel appearing for the petitioner, also heard the learned APP who has submitted that the service on the respondent number 2 is complete. However, none appears today. In the circumstances.
Amicus curiae, my lord.
Amicus list kon ase je number 5 of Jijonas. In the circumstances, so-and-so is appointed as the amicus to assist the matter. Learned counsel for the petitioner shall serve copy of the petition on the learned amicus. Srimati, kiman boli kolo mo serial number 5. Dr. Pooja Agarwal. Learned counsel for petitioner will serve a copy on Dr. Pooja Agarwal. List this matter again on
the earliest post.
4th.
Lordship.
4th. 4th of February, the CD.
The city is here, so it may come idea also, my lord.
The learned APP shall retain the CD. The observations made in the
28,
earlier
29,
order
my
dated
lord.
21/2026 shall remain extended,
That
allowing
order,
the,
my lord.
allowing the family members of the petitioner to take necessary steps to give
In terms of the order dated so and so.
to give proper medical care to the arrested accused in terms of the order dated 21/2026.
201.
21/2026.
Yes. Sometime 21.
21 and 20.
Very difficult.
We shall have to keep a note. We'll make it
The
20.
date maybe cities here, my lord. So we'll supply copy today, my lord. So amicus curiae, my lord.
Yes.
So
We'll have it on the 4th, sir. Prior to that, it's too heavy.
Here, my lord. That's why I'm saying.
No difficulty. If the person has to undergo the surgical intervention, he'll anyways
see
be
that you, my lord.
he
Even
will
if he's
always
in the hospital, my lord.
he will anyways be in the hospital for that period.
But if he remains hospital, if he gets bail also, it will help them, my lord, also. Personal care will be required, my lord.
Prior to that, it is second of February.
Anyway,
Whose medical report?
No, we have submitted last day.
Victim.
Oh, victim.
Victim medical report is not there. The learned APP has submitted that the medical report of the victim is not available in the case diary. The learned APP will be at liberty to requisition the same from the investigating authority prior to the next date of listing. 2nd of February.
Become 65.
My lord, 65 may be taken at 2, my lord. I haven't called at 2, my lord. The other matter is there. Obliged to.
এটা মেটাৰ আছে ন চুপ্ৰি চাবৰ একেলগে এটা পিছত এটা দি দিব এটা সিটো ডিছপ'জ কৰিম এইটো দি দিব
66.
52 days. Huh? 52 days. My lord, intermediate quantity 52 days, my lord. Last date, your lordship. 103 gram only, my lord. 103.5. Go back, my lord.
assuming it is
Yes.
assuming it is no
From the hotel. Anyway.
Two independent witnesses are also here. They have also stated.
quantity is intermediate
Only
52
less,
days done.
only 103, my lord.
FSL report awaited charge sheet not submitted
47 days.
Huh?
No, 52 days.
57.
No, arrested on 312. 312.
we'll consider it we'll consider it we'll granting the
Special
intermediate quantity objection to record কৰিব intermediate quantity asile 30,000 one COT of the like two COTs of the like amount oh
Kamrup Metcomar session, it will be a special judge.
Kamrup Metro
It will be a special judge.
would
My objection on the ground of conscious position.
Learned APP has objected to the prayer for grant of bail, stating that the contraband has been found in conscious possession in the presence of two independent witnesses.
Item
Disposed of, huh?
Item 27.
TCR was received, you need a prayer, folks, so yes.
May I please, your lordship? In this case, opposite party appeared, my lord. Kindly peruse FIR, that is case number 16. The case was registered under section 376 IPC with section 4.
Circumstances, this court directs that the petitioner shall appear before the learned trial court on or before, when can you appear? Any date, tomorrow?
Not tomorrow. It won't be possible, your lordship.
Very dangerous.
Next week.
Give us the any date part. That is why we have asked you, when can you do it? Appear before the learned trial court on or before 10th of February 2026. And to pray for regular bail. It is provided that if prior to his appearance on 10/2/2026, he is arrested, he shall be released on bail on furnishing a bond of rupees 30,000 with two sureties of the like amount, subject to the satisfaction of the arresting authority. Full stop. The petitioner shall invariably appear on or before the 10th of February 2026 before the learned trial court to pray for regular bail, and in his failure to do so, the privilege of clearance bail granted by this order shall remain lapsed. Shall lapse. Full stop. It is further provided that the prayer for regular bail before the learned trial court shall be considered on its own merits without any reference to the privilege granted by this order.
28.
May be disposed of.
Please, your lordship.
FSL report was called for in this case. I am on interim.
You are on interim, yes. The learned counsel for the petitioner is present. The learned APP has submitted that although the scan copy of the TCR has been received, it appears to be incomplete. Stop the learned, the registry to communicate with the learned trial court for furnishing the full copy of the trial court, full scan copy of the trial court records, full stop. The
Along with the
FSL
case diary and charge sheet.
along with the case diary and the charge sheet. So what about the FSL? Huh. List again on Jackson. Interim or আছে? 9 February 2026. Interim protection granted earlier to continue till that date. Yep.
Please, Your Honor. Interim was there.
Case diary called for.
Interim may be continued.
Mr. Swenson, learned counsel appealing for the petitioner. Learned APP has submitted that the case diary as called for has not been received. List again on 10/2. Stop
Interim may
awaiting the case diary. Interim protection granted earlier to continue till then.
May I please, my lord? My lord, I'm on interim, but in the meantime, charge sheet has been filed. And in the meantime, I was asked to appear before the court, and I appeared again. I have been released on bail. I appeared on 22/12/2025. Now I'm again released on bail, and the case has been committed to session court.
It has been committed.
It has been committed to session court. I was granted bail by the again SDGM on my appearance. Even again, I'm also on interim. I appeared on 22/12. Because in the meantime, charge sheet was filed.
You are on interim protection.
I was on interim protection.
And thereafter you appeared before the CJM.
Thereafter, I appeared before this SDGM. I was summoned to appear. I was granted bail with a bail bond of 20,000. Thereafter, the case has been committed to session. Again, now I have to appear before the session. So practically, my lord, that interim may be kindly met absolute because I have been cooperating with the investigation. Whenever I'm asked to appear, I appear even before the court.
But Mr. Swenson, counsel appearing for the petitioner, also heard the learned additional public prosecutor in the matter. The learned counsel for the petitioner has submitted that the petitioner had appeared before the investigating officer as required by the order of the court on 29/8/2025. As required by the order dated 29/8/2025 of this court. Full stop. The learned counsel for the petitioner has further submitted that the charge sheet in the matter has been submitted, and on his appearance before the learned SDGM, what?
On 22/12, I appeared.
No, SDGM what? SDGM Kachar Lakhipur.
SDGM Lakhimpur. My lord, if your lordship
SDGM
permits,
Kachar Lakhipur.
if your lordship permits,
He has been granted bail
order sheet.
during when the case was committed to the court of the learned
Session
judge Kachar Akram.
Filch.
Full stop. And on his appearance before the learned subdivisional magistrate M. Kachar Lakhipur likhile, he was allowed to remain on his previous bail till the date for his appearance before the Court of Sessions as fixed. Stop. The learned counsel for the petitioner has thus submitted for the interim protection granted to him to be made absolute. Full stop. The learned APP has submitted that there are that he is not there are no instructions to negate the contention that the petitioner has appeared before the investigating authority and has also been granted has also been allowed to remain on previous bail by the learned SDGM, Kachar. Stop. In view of the above, since the case is already committed to the court of the learned session district and session judge, the interim protection granted to the petitioner by the order dated 29/8/2025 is hereby made absolute. anticipated bail application accordingly disposed of. Anything else to be recorded?
Yes. 32. I appeared, Lordship.
You appeared where?
Uh,
You would appear or you have appeared?
I have appeared, Lordship, 14/12.
Huh.
14/12, I have appeared. Lordship.
The charge sheet has been submitted.
If entry may be made actually, Lordship. Already I am
The
cooperating.
charge sheet has been submitted.
I am cooperating, Lordship. As per the Honorable
So-
Court's order, I have appeared, Lordship.
You would pray for regular bail before the trial court till your appearance. We keep you on, we keep the. No. Till your appearance.
Lordship.
It will be for him to see.
Lordship. Otherwise, I am cooperating. I have appeared as per the Honorable Court's order, Lordship. And several occasions I have appeared, Lordship.
IT Act. Just a minute. Cyber fraud. Heard Mr. Swain counsel paying for the petitioner who has submitted that the petitioner has appeared before the investigating authority as required by the order dated 8/12/2025. Text of the learned APP has submitted that the matter has been charge sheeted. It is now pending trial before the learned trial court. Charge sheeted by charge sheet number so and so.
28.
In view of the above, the privilege of previous bail granted to the petitioner by the order dated 8/12/2025 is made absolute. We keep it at made absolute, little. IT Act. Made absolute, AB disposed of.
Obliged.
Item 33.
It also looks at charge sheet has been submitted.
Yes, sir, charge sheet has been submitted. What would you like to do?
My lord, at the post.
Huh?
Showcase, my lord.
Would you like to appear before the trial court? Huh? It will speed up matters both for you. You can defend yourself more properly. You were not arrested during the trial, during the investigation.
My lord.
Then learned, heard Mr. Swain, learned. Heard Mr. Swain, counsel paying for the petitioner also heard the learned APP that it has been submitted that the charge sheet has been filed in the matter by charge sheet number
105/25. Dated 8/11.
Stop. The learned counsel for the petitioner prays for liberty to approach the trial court. Stop. With the liberty as paid for being granted, this AB is closed.
34.
You would like to object to the same? Yes. You would object to the same? He is saying that you are on interim and CD is not received. Would you like to object? No. Heard Mr. Mullah Khan, learned counsel paying for the petitioner. The learned APP has submitted that the CD is awaited. Place the matter again on interim of February, awaiting the CD. Yes.
Interim.
Interim protection. Huh? CD nahi lete hain khuji ko CD. Mo kyo khujim CD. Mo kyo remind. Mo TCR dim. Interim order to continue. Huh? And he's running for his life. Mr. Sharma, he's running for his life. Your CD is not coming. Okay.
Any short date, please.
List again on very nice. Short. 4th of February 2026, awaiting service report on the respondent number 2 and also the CD.
Much of that.
37.
May it please your lordship.
Huh?
May it please your lordship. Court petitioners, your lordship. Petitioner number 1 is on interim and he has appeared, your lordship. This is a family dispute affair by the wife, your lordship. Allegations, petition number 1 is the husband, 2 is the mother-in-law, 3 is the brother of the husband, and 4 is the wife of the brother's husband. That is petitioner number 3. FIR lordship will get at page 9, your lordship. And in the allegation, your lordship, the day of occurrence, your lordship, the whole allegation is against the mother-in-law, basically. And lordship, this is a FIR was belatedly filed after about 6 days of the incident. 498 matters, basically, your lordship.
Mother-in-law, brother-in-law, sister-in-law.
Yes. Husband, mother-in-law, brother-in-law, and brother-in-law's wife, that is sister-in-law. They live in a common job. House program. But the incident that she has narrated on 5/10/2025, on that date, only the mother-in-law was present. Husband was not present, brother-in-law was not present, sister-in-law was also not present. And subsequently, after about 6-7 days, on 13th, 10, the affair was lost.
One is the husband.
One is husband.
2 is the mother-in-law.
Mother-in-law.
3 and 4 are the brother and the
Brother-in-law
sister.
and
Yes.
But you can look the CD. The CD is not updated. So the statement of the husband is not in the CD. But legally there is a medical report that she has some injury and which is previous. That is clear. And her statement I have remarked. First place is the medical report.
In going by the FIR itself.
Yes.
Mother-in-law instigates the other react. If the husband has already appeared, if his statement has been recorded, if we take his word for it,
yes,
his custody may not be required as of now. She is safe in her parents' home. We reject it for the mother-in-law. For the mother-in-law, we reject it.
Others look for statement. Others may also be.
No. What I was thinking is, if we make it absolute for the petitioner number 1, the husband who was not present on that day, 2 we can reject.
We can reject, but my submission will be lordship.
Take it up all at the same time.
At the same time, lordship can directly and for the other 2
to go and appear. Give their statements.
Including the mother, she is aged about 70 years, your lordship.
She's strong enough to pull someone by the head and break their hands.
But I have instruction is that during fight, she fell down herself and there was a scuffle.
Mother-in-law should not be involved in physical fighting with the daughter-in-law, should it be?
It is unlikely 70 years and she is 30 years. I don't know who have fought with who.
Call for the Mr. Swen, Mr. M.S. Laskar, learned counsel appear for the petitioner, and Mr. Swen, learned additional APP has submitted that although the CD has been received, it is not updated and does not contain the statement made by the petitioner number 1 as directed by the order dated 3/12/2025. He prays to be allowed to produce the updated CD before the court footstep prayer is allowed. List again on 18th of February 2026. full stop, it is provided in the meantime, the petitioner number 3 and 4 shall appear before the investigating officer within a period of on or before 3rd of February 2026 to have their statements record and cooperate with the investigation. Full stop. It is provided in the interim. And in the event of the arrest of the petitioner number 3 and 4, they shall be released on bail on furnishing a bond of rupees 30,000 with a suitable surety of the like amount, subject to the satisfaction of the arresting authority under the following condition. Egita condition age di dibo. Tinibar thaka kita, ha? Stop. The interim bail for the petitioner number 2 has not been considered as of now.
Obliged, Lord.
আছে যদি মানুহ মাতি দিওঁ কেই নম্বৰ লৈকে গ'ল এই বহুতকেইটা আছে at 2, then we'll come back at 2.
TCR not has been called. It is not available. Otherwise, मतलब statement now.
If the wife is
on their version. Then on their version, otherwise,
you don't want it to proceed.
No, Lordship.
Chances of conviction.
Yes, madam. Yes.
Reason is that we are living together.
That is in one case that always disturbs me. In one of the cases, Supreme
Yes.
Court has said that you are making a victim live with a perpetrator and she has to continue life.
But
No other choice.
as a lawyer, I feel Lordship laws are not inconsistent because child marriage, it's not a void marriage, it's voidable.
One affidavit before the notary, my lord,
Just
page
whether
20.
she has filed,
No,
whether
no,
any
No,
filed,
in this case, I have not.
has submitted that she has personally interacted with the alleged victim and is under instructions that the alleged victim, respondent number 2, does not want to pursue with the case and she is in happy marital life till now. Huh? The counsel for the petitioner has drawn our attention to the affidavit cum declaration annexed to this petition, where the respondent number 2, that is the alleged victim, has made statements that she had eloped with the petitioner and entered into a marriage with him of her own will, and that she would have no objection if the proceedings initiated against the present petitioner is set aside or quashed. Stop. The counsel for the petitioner has drawn our attention to the judgment of the Honorable Supreme Court in State of Haryana versus Bhajan Lal, reported in AR 1992, Supreme Court 604, where at paragraph 102, the judgment has laid down as follows. Please take from page 31, para 7. The next paragraph. Having heard the learned counsel for the parties and also the learned APP, this court is of the opinion that the ratio laid down in Bhajan Lal is applicable to the present case. Full stop. Since the so-called victim girl has come forward to state that she is living happily with the petitioner herein, and even after attaining majority, she does not have any wish to nullify the marriage at this stage, there is little or no possibility of conviction of the accused petitioner in the future in the pending criminal proceeding. Full stop. Allowing the criminal proceeding to continue would only be a prolongation of the judicial process. Full stop. In the opinion of this court, This is a fit case for exercising the powers under section 528 of the BNSS 2023, full stop. The criminal petition is accordingly allowed. The proceedings of special P case number so-and-so arising out of so-and-so against the petitioner is hereby set aside and quashed. The criminal petition is disposed of. You seem shocked. Why?
My lord,
You seem to be shocked. Why? That is what you want to see? Yes. Would you like some compensation for the case? No. For initiation of the proceedings? No. Yes, sir, Mr. Goswami, anything?
Yes, Lordship. He was produced before the court on 18/6. And court has rightly observed that today on being arrested by Karimganj police in connection with the above noted case, perused the FIR forwarding report of the arrested accused person, arrest memo, medical examination report, inspection memo, notice under section 47 BNSS and under section 48 BNSS with ground of arrest and accused challan of the arrested accused person. That observation of the made by the learned court below us. And here, Lordship, only error part is here 18/6 and the 47 notices.
17/6 they are taken
They
into
are
custody.
apprehended on 17/6 at 12:11:15. And in 47 notice, the time and date and of arrest is 18/6/2025 at 12:30, I think. It was written.
That was taken into consideration by the apex court in the matter which we have referred in permit.
Yes, Lordship.
Similar circumstances
Similar
were there.
circumstances.
The person was picked up, time of arrest shown at a later time on the next date, and then they had proceeded. Supreme Court said no. The moment he comes into under your detention and if you arrest him, it goes back to that time when you detained him. 24 hours starts from there.
That I have got
Not
that.
from the time you write down, now I have arrested him.
That is clear, actually. Here only, that part is here, 18/6/25, 12:30 PM.
That is wrong. And
In a
also
40
the 47 notice that is
47 notice.
produced before us, the 47 and the 48 notice.
Yes. But learned trial court below observed that the 47, 48 was followed and served
So
as per their order. Also.
does it require revision for us to now decide whether it was wrong or right? Trial court may say so. We have seen cases where, because the same team is here.
Yes.
Where in the absence of a 47, 48 in the record, trial court is saying yes, seen. These are routine orders. Case to case, they are not maybe taking up, I don't know. So we'll go by that part of the committee. Where were you arrested?
At
In
Hadarashi area.
You were arrested by in Karimganj.
Yes.
Where do you belong to?
I belong to Karimganj itself.
You belong to Karimganj.
PS Karimganj, District Shivun.
This bill application has been referred under section 483 of the BNSS of Gujarat, seeking regular bail to the accused petitioner in connection with Karimganj PS case number 290 of 2025 corresponding to GR number 873 of 2025 pending before the court of the session judge, Shri Guru, the petitioner, full stop. The petitioner was arrested on 17/6/2025 and has been in custody since then. The learned counsel for the petitioner has submitted that the petitioner was in fact detained on where is that part? That forwarding part, where we had seen the time, yes, was in fact detained on was detained prior to 2:20 p.m. of 17/6/2025 during a NACA checking near Sadarshi GP office in Karimganj. Full stop. The forwarding report of the arrested accused person, while detailing the brief of the case, records that the NACA checking was conducted from around 11:15 a.m. when the vehicle in which the petitioner was traveling was intercepted, and after a search and recovery of some contraband material, the report page 16, did I say? Where was the 2:20 p.m.? Yes, Council, help us. Where is the 2:20 p.m. part?
Your Lordship, it is in the FIR page.
Full stop.
FIR is at
As
page
per
9.
the FIR lodged on 17/6/2025, it is reflected that the informant, along with staff, the apprehended person, which included the petitioner herein, and the seized articles, departed from the place of occurrence at 2:20 p.m. and arrived at Karimganj PS at 2:40 p.m. The learned counsel for the petitioner has submitted that the notice of information of ground of arrest under section 47 of the BNSS reflects that the date and time of arrest is shown as 18th of June 2025 at 12:30 p.m. And in fact, it is a matter of record that the petitioners were produced before the learned remand court on 18/6/2025, at least after 12:30 p.m. when the time of arrest has been shown. Is it not? The learned counsel for the petitioner has therefore submitted that without prejudice to his other arguments, that the detention of the petitioner having exceeded 24 hours prior to his production before the remand magistrate, his arrest and further detention becomes illegal in the eye of law, and therefore the petitioner is entitled to be set at liberty. The learned counsel for the petitioner has further submitted. What was the other submission? That was the only submission.
Section 36 notice,
Has
witness has
also-
not been,
Has also submitted that there are violations of the provisions of section
36 of the BNSS.
of the BNSS and
I would like to press only this one.
full stop. The learned additional PP has submitted that the petitioner, that the petitioner has been shown arrested on 18/6/2025 at 12:30 PM and his production before the learned remand magistrate on 18/6/2025 displays that he has been produced within 24 hours of his being shown arrested. Full stop. You said one more thing. What did you say? The records before this court reveal that the petitioner had been actually taken into custody at least prior to the search party leaving the place of occurrence and arriving at the police station. Therefore, the petitioner had been taken into custody on the 17th of June 2025 prior to 2 o'clock. There being no specific reference that the petitioner had been produced before the remand magistrate within 24 hours of his being taken into detention. This court is of the opinion that the detention of the petitioner thereafter has been rendered illegal. Stop. We'll fill in the other part. In view of the above, we'll keep one or two paragraphs kept. In view of the above. This court
Your Lordship,
directs his
on 9th, the case was transferred to Additional Session Judge FTC Shribhumi, and the case number is Special NDPS case number 69 of 2020. That may kindly
the
be read.
counsel for the petitioner has submitted that the case now stands transferred to the court of the
Learned Additional Sessions Judge FTC Shribhumi.
Sribhumi and is pending therein. Stop. In view of the above, this court has no alternative but to hold the further detention of the petitioner to have been rendered illegal, and therefore he would be entitled to the privilege of bail. Stop. This is directed that the petitioner be released on bail on furnishing a bond of. We put up those conditions. Give the conditions, you can have it.
Deeply or prejudice.
Nothing else to do.
NTC, Lordship, I have gone for that insufficient materials, Lordship. Only thing I want to place with Johnson judgment, Lordship, regarding because it is very unfortunate for us because a person was brutally killed by several witnesses before action. A person was brutally killed by someone, and now only because of that roundup was not sufficient.
You miss out one part of the order of the judgment of the Supreme Court. It can be redone.
Yes.
Giving him the ground of arrest.
Yes, Lord.
So the unfortunate part probably does not only end in this court. It continues when the authorities deem it fit not to use that part of the law. That liberty is there.
Yes.
Mihirajesh Sahib, that liberty was there. Was it?
But 21.5, Lordship. I have want to show this, Lordship, to showing respect to my seniors, Lordship. 20.1.5, Lordship, while Section 50 CRPC is mandatory, the consistent judicial approach has been adopted prejudice-oriented test when examining alleged procedural lapses. The mere absence of written grounds does not ipso facto render the arrest illegal, unless it results in demonstrable prejudice or denial of a fair opportunity to defend. The next para, Lordship. The High Court, however, relied heavily on the alleged procedural lapse as a detrimental factor while overlooking the gravity of the offence under Section 302 IPC and the existence of prima facie case
it noted inter alia that there was no mention in the remand orders about service of memo of grounds of arrest. The arrest memos were allegedly template based and not personalized. An eyewitness had not stated that they were present at the time of arrest or had signed the memos. Relying on that well of the fact of Pankaj Bansal versus Union of India and a Prabir Prakash Secretary, it concluded that from that date onwards, 23 10 23 onwards, failure to serve detailed written and individual grounds of arrest immediately after arrest to the violence entitling to accused on bail.
If there had been some indication
Yes, but
with the murder of so and so person, 20.1.6, we would have said you know who was killed. Now you know when he was killed. So now you can find out your ways to defend yourself. Here, you are accused of murder. 2 hours before he is produced before the magistrate. Within those 2 hours, what details will he find out? Murder of X on 22nd of January. The man can stand up to say 22nd of January, I was doing my duty in the High Court. Is it not? You telling you are accused of murder. Whose murder? Where murder? What time murder? That how can he defend? If I go into this part of it, then I will have to give that observation also. Some reference to the incident. 2 sentences and
only 2 sentences are there.
I was waiting for you to come up with Darshan. Reading of it shows that some reference has to be there. Here nothing. You are accused of murder.
Only written that you have been arrested as you conspired murder and assault of the victims. That part.
If you look at the SMS part, it is more dangerous. আপুনি ভুক্তভোগীৰ হত্যাকাণ্ড ষড়যন্ত্ৰ কৰা অনুসৰি গ্ৰেপ্তাৰ কৰা হল। ভুক্তভোগীৰ হত্যাকাণ্ডৰ ষড়যন্ত্ৰ, the translation is wrong. ভুক্তভোগীৰ হত্যাৰ ষড়যন্ত্ৰহে কৰিলে তেওঁ। In the English part, you have conspired in the murder and assault. Assault comes in. When the English goes. But Mr. H.R. Chaudhary, Learned Senior Counsel. Anything else, Mr. Chaudhary? Learned Senior Counsel, assisted by?
Yes.
Learned Counsel paying for the petitioner, also heard. Mr. D.P. Goswami, Learned CPP appearing in the matter. Application being for bail. Post type of person. Mr. H.I. Chaudhary has drawn the attention of his court to the notice under section 47 BNSS served upon the petitioners herein to contend that the same are cryptic without any description and are insufficient to suffice the rigors of the notice as required under law to be served upon the arrested person, drawing our attention to the notices under section 48 of the BNSS purported to have been served upon the family members of the relatives of the friends of the petitioners. The Learned Senior Counsel has again asserted that the same are insufficient to give any idea to the relatives, family or friends of the arrested person enough information to arrange for the defense or defense during prayer for custody of the arrested persons, full stop. The Learned APP has submitted that both the notices under section 47 and 48 of the BNSS refer to the PS case number and also are explicit enough to inform the arrested person and his friends, family, or relatives as nominated that he has been arrested as he was involved in a conspiracy of murder and assault of the victims, and he has been arrested as he was directly involved in the case as per the statement of independent witnesses. We have perused the notices and we have also applied our mind to see as to whether the notices would suffice the requirements of the rigors of section 47 and 48 of BNSS. We are constrained to observe that 7 except name the case, 7 except cite the case numbers against which the petitioners were arrested. The information given given as the grounds of arrest cannot suffice the requirements as laid down by the Honorable Apex Court in the case of Ahmed Mansoor's and others versus the state represented by Assistant Commissioner of Police, reported in 2025 Live Law within bracket SC 1026. Stop. It is apparent that the ground of arrest as made known to the arrested person and his friends, family, or relatives do not contain any detail in the hand of the investigating officer, and it is also devoid of the particulars of the person who had been allegedly murdered or the victims who had been assaulted. Stop. The learned counsel for the learned APP has drawn our attention to the case law, to the case of State of Karnataka versus Darshan, where at paragraph 20.1.6, the Apex Court had observed that mere reliance on an alleged procedural lapse would not be a determinative factor while overlooking the gravity of offense under section 302 IPC and the existence of a prima facie case or otherwise. Full stop. In the present case, the facts differ to the extent that the notices herein do not even divulge the details of the person allegedly murdered or the details of any of the victims who were allegedly assaulted or the nature of the evidence which is available against the accused arrested persons. In view of the above, this court does not have any other alternative but to hold that the arrested persons or their friends, relatives, or family did not have sufficient knowledge were not given sufficient knowledge as required under the law, and therefore the continued detention of the arrested persons are rendered illegal. In the facts and circumstances, this court directs that the petitioners, namely shall be released on bail on furnishing a bond of rupees subject to the following conditions. 1, 2, 3, 4, keyboard. I will say keyboard. The other sessions that the learned trial court would be subject to the satisfaction of
Session Judge Morigo.
Session Judge Morigo. The Session Judge Morigo shall be at liberty to impose such other conditions upon the petitioners while accepting the bail bond. Should we observe that this order would not bail application disposed of? We have just given the outline. We'll fill up the details as necessary.
May I please, your lordship?
After some time, let the matters be.
Every item, nine.
Lordship, I'm sorry I could not attend the first half.
Okay, sir.
Now the clearest bill application, my lord.
Huh?
Clearest bill application. The lordship will find the FIR at phase, my lord, 15. He has been named in the FIR, my lord. Only thing, my lord, from the contents of the FIR, my lord, case of NDPS and my lord, the Arms Act, those has not been recovered from his possession, my lord. No narcotic drugs have been seized, my lord, in this case.
Empty container, tobacco container.
Three red, three orange and one yellow colored plastic tobacco container.
Container, my lord. No NDPS drugs.
Saratini. Who keeps a receipt for that? Extortion having coming in. With extortion having coming in, sir.
From any of the. My lord, regarding those motorcycles, my lord, there is no report of any theft or anything, my lord.
That is more dangerous.
That is why, my lord, if it is stolen motorcycles, my lord, or bicycles, there ought to have been some, my lord,
No,
affairs.
it is not stolen. The allegation is that when someone does not repay, he brings the motorcycle and keeps it at his home.
That would be like that.
That will be robbery.
That is hire and purchase agreement, my lord. Some agents are there.
One
They can, my lord.
One document.
At that time, registering the.
Why was he not arrested on the spot? He was not in the.
He fled away.
It is in the affair that.
He fled away. He managed to flee away. At the time of the raid by the police, the said Dibbajyoti Dutta managed to flee away. But that Arms Act and Section 27 and NDPS was subsequently added. So why subsequently added? It is as per the FIR, not details are not there, but something maybe there because of that the subsequently added. When it is registered page 17, that Arms Act and Section 27A was not there.
Not there, huh?
Not there. So subsequently added means subsequently there some materials must be available, my lord. So should be prepared.
From one co-accused, my lord, these empty cartridges were received, my lord. That we got, my lord, subsequently the seizure, my lord, list, my lord. One, my lord, Sirazul Islam was arrested in connection
On
with it.
being interacted, the accusers stated that when ammunition was recovered, there was some recovery from the.
From Sirazul.
From?
From one Sirazul Islam, co-accused, my lord.
I think we can have a look at the case diary.
Link with the
Consider
Sirazul.
itself.
My lord.
Because arms is there,
Arms Act 27A.
DPS is there, again the bikes are there.
But from affair, my lord, it does not reflect that, my lord, NDPS or psychotropic substance have been recovered.
The recovery was not there, but they had gone there to catch NDPS.
Yes.
Then they found all the
Yes,
other
that is
things.
there. Information was there. But nothing has been recovered, my lord.
One person is already in custody.
He is already in custody.
Some progress in the investigation, perhaps.
My lord, yes, my lord.
When can we have it?
From Jorhat, my lord. Fourth, fifth. Not prior to that. Fifth.
4th of February.
I'm obliged.
Call for the CD, 4th of February.
Obliged, Worship.
Yes, sir.
Yes, ma'am. My lord, your lordship, can you see this lady having 4-year child, my lord, is arrested next day of the occurrence. One of the two families who reside in the same premises in the different floor, my lord. So The other one, your lord, can you see the FIR, my lord? Can you see FIR page 30?
Page
1-3. No, 1-6, man.
1/6, yes.
1-6. 1-6. Your lordship may come to third paragraph, my lord.
Some Jelina Begum.
I am the wife of Ayatul Ali.
Huh. So
Now-
all this happened,
Now your lordship will find name of details accused person, my name is not there. Then you kindly see the FIR. Next, they must kindly see the Caesar list one. Page 21.
yes.
I was arrested on 15/12, date of occurrence 13 mile. Date of occurrence is 14 mile. Next day, the 15 is arrested 12:35 AM. Your lordship will house of Ayatul Ali, Caesar, place of Caesar, my husband.
Ayatul Ali,
My husband name.
the first recovery is not from the house of
No,
Ayatul
no,
Ali.
not from my. From the another house, my lord. From the house of one my
Maitul,
Ali.
huh?
Mamtul Ali. And from me, my lord, your checks, etc., these things have been seized. No contraband. Then your lordship will find that other things were seized from other person, page 20, to your lord's kindness. From Jagina Bibi, your lordship will find. Then I take your lordships to my lord, the forwarding report of the present petitioner one. Page 27.
Page 20, after page 22, what happened?
Next page 20. That's the contraband is from the house of my lord, from Jagina, etc. My lord.
No, this page 25. Where is the type copy of page 25?
Page 25, type copy, your lordship will find page 22 onward. Place of Caesar in the house of the premises of Ayatul Ali and Mamtul Ali. The same
Which from
premises.
which house is not given?
Yeah. So these things, my name is not there.
Jelina.
Jagina.
Then?
Yes, I am Nazrin. Then you will kindly see the FIR, my lord. What is forwarding report, page 27. Grounds of arrest. The credible evidence, then number 3, my lord, arrestee is a close family member of the number 3, my lord. A prime accused, absconder, Ayatul Ali, my husband. Now come to kindly see 48, my lord. Notice. These are on merit, my lord. Not from conscious possession, not from me, anything, my lord. Nothing is that, it is on merit. Then kindly say, my lord, 48 notice was issued to Gaubuga, my lord.
Who?
To Gaubuga, who is neither family members or anybody, no relation at all, my lord. Kindly see, my lord, page 36. Type को बनाएंगे. Type को बनाएंगे. Huh? The loss kindly see, my lord. He is Gaubuga, and your loss will find. Your lordship got it, my lord, page 36. He is my lord Wasif Saikia, Gaubuga of Udina. Udian.
Yes, sir, Mr. Sharma.
Yes. Lady, my lord, having 4-year child, my lord. And she is the next day she was, my whole case, my lord, next day she was arrested. Nothing from conscious position, nothing is there. On merit also I have a case, and on 48, so there is nothing at all. We made categorical statement, your lordship will find that he is neither family members, nor relatives, nor friends, nor till today it has been served to us.
47 served to you.
47 strikes to the my lord that year. I am not on, I am only 48.
Yes, sir.
Lordship, here, I will come to 48 later, Lordship. Lordship will kindly come to the FIR for a moment, page 16. Here, Lordship will see second paragraph.
CD has come.
Yes, yes.
Oh, yes. So
Based
now
on
you are on page 16.
16, Lordship,
Ah.
FIR. FIR, Lordship will see the second paragraph. First paragraph, Lordship will see, source information was received that a huge consignment of narcotics, opium, has been received from Manipur by infamous narcotics dealer Aitul Ali and his brother Mamtul Ali. Those two are brothers. Second paragraph, based on the input, a raid was carried out in the house of Aitul and Mamtul and recovered 86 kg. 86 kg is, Lordship, I don't know how to put it. 2.5 kg is the maximum commercial quantity.
5 crores, 16 lakhs. 5 crores, 16 lakhs is
Yes.
commercial value.
Only.
Only.
Now, Lordship, with the lines, Lordship will see, which has been packed in 45 numbers of packet, getting wind of impending police presence, the brothers Aitul and Mamtul fled away. However, Jarina Begum, wife of so-and-so, who is also a partner in the narcotics trade, was stopped from fleeing away. Besides her, other persons were present in the house and were in the process of opening the opium packets, waiting to deliver the opium to other places, etc. And these people, as detailed below, were apprehended so-and-so. Now, Lordship, when the process was done, Lordship, I talked to the IO today also. The whole family, Lordship, are engaged in this business. They import it, Lordship, they make small packets and deliver it toward Assam. The whole family is involved in it, Lordship. She is the wife of Aitul Ali. She was not at home at that point of time. And that came to her rescue. She was arrested the subsequent day. So that does not mean that she is not involved in the trade. First thing, and Lordship, this is commercial quantity. Section 37 will have to be satisfied first and foremost. Based on these grounds, whether that satisfaction can be taken by your Lordship, that she is not involved in the offense. Now, Lordship, another thing. They have raised the ground of 48. Lordship will kindly come to the 48 itself. That is, Lordship will find that page. Page 36. Page 36. Also from the case that I am pointing out, Lordship, when she was arrested the next day, Lordship, from a different locality, no family members were present because all were under custody. Her husband and the other main accused, they are absconding. So no one was present.
Her husband is absconding.
Yes, Aitul Ali and Mamtul Ali are yet to be arrested. These two are the main co-accused. They are the main accused persons. Her husband is absconding, Lordship. Now, Lordship, when none of the family members were present, she was asked, whom should we give the 48? She nominated the village headman, and as a result of which the notice was served on the village headman. That is reflected in the case diary also, and also in the 48 notice. So there is no question of non-compliance, Lordship. I can read it from the here also, Lordship. The accused, when arrested, remaining family members of the accused absconded and no one from family were found to serve the notice under 48 BNSS. The accused was asked as to whom she would nominate to receive the notice under 48. At this, she stated that Wasif Soikia, who was the village Gaunbura as well as the co-villager neighbor, could be served the 48 notice. On being nominated, so and so grounds were given. So that is the case. Investigation is a very crucial stage, Lordship, because this is not only a case of, Lordship, narcotics, it is a supply from outer states. Here, Lordship, they happen to be the stockists. They are the kingpin of the case, and these two persons who are absconding, they are involved in other cases also. That reference is also there in the 47, 48. So at this stage, Lordship, I humbly pray that it may be rejected because investigation is still going on, very crucial stage. If Lordship wants, I can give the CD, Lordship.
Your Lordship may see the city, no problem. Your Lordship will decide. Yes, my question, my lord, on the face of it, whether I nominated my house till today, my mother was there, my lord, my husband's mother, my mother-in-law, other family members are there, my lord.
That is why we had raised these questions on earlier occasion also.
Yes.
Who did you nominate?
Yeah. Now, who has to nominate, my lord, because
Someone has to be nominated by the petitioner.
Yeah. He cannot nominate somebody, my lord. They have to issue to the one.
No, perhaps it's a little bit different.
your lordship kindly see, they have to communicate to the family. Family members there, my mother is there, my lord. In the house itself. And that Gauga mother who resides somewhere else, by 2 kilometers, 1.5 kilometers, you have stated, my he resides. No relation at all, my lord.
We have 48 for a moment.
And we have stated till
Section
today, my
48.
lord, it has not been served.
Section 48.
Yes, 48. No, by what one? 48. Hmm. Yes, ma'am.
Every police officer, other person making an arrest shall forthwith give the information regarding such arrest and place where the arrested person is being held by the relative, as may be disclosed or nominated by the arrested person. Now, even before this, bail application came,
So even my nominated, it is the statement given by my subject to what your lordship, my lord, that is up to, because he is saying, my lord. Now, on merit also, my lord, I am just coming. Both fact, merit also, my lord, next nothing was 37 will come or not, my lord. That is the only question here, my lord. Even no contamination is from her. She was present in the house. She was not taken to custody. Next day, she only on the basis of co-accused statement, my lord, she was taken to custody, my lord.
she was not present in that house.
She was, my lord, she was.
There are two different houses.
Two different house.
So she
So nothing was given from my house,
So
my lord.
14-12-2025.
It was seized from the
was from
another
the
house of Mamtul Ali.
Mamtul.
Mamtul.
They raided Mamtul and they arrested all these persons. On the next day,
On the basis of co-accused statement.
Aitul's house was raided
Yes. And these things were found. No contraband, your lordship.
on 15th.
On 15th. Seizure list kindly see, my lord. Checkbook, etc., everything found, it is seized, my lord. No contraband seized.
Non-recovery from her house. After a day, we are not impressed because one day is enough.
But seizure, my lord, your lordship, from
At this
seizure
stage,
list.
Mr. Chaudhary, at this stage, no, I cannot bring myself.
My lord,
Okay.
48 not complied, my lord.
The investigation not being.
But so far, this lady is concerned, my lord. Yes, my lord, Aitulali, Mamtulali, I agree, my lord. This lady is 437 also come, my lord, CRPC. Even, my lord, CRPC applies in the NDPS also, my lord. Also apply. Women, my lord, infant, that they are also, my lord, lost.
All that given the quantity involved.
No, that, my lord, this is nothing from her, my lord.
The involvement
Not
of
from
the,
her house. This seizure is not from her, it is from her house, only checkbook, etc., my lord.
even though we are a,
No, that, my lord,
we are-
I understand this
we
type
are
of cases.
we are of the view that bail is the rule. Here we cannot.
But
bring
co-accused
ourselves to
statement,
stand-
my lord, Tufan Singh is your lordship, my lord.
Huh?
Co-accused statement.
In trial.
Tufan Singh, no, trial
At this stage
does
of
not
trial.
mean, my lord. 48, my lord, also your lordship, 48, then co-accused statement.
The explanation 48 is given. Even before that ground of 48 that.
On merit also, my lord, your lordship, sir, on merit. On merit, my lord.
Not at this stage of the investigation, sir. Little bit more time.
I do not know, my lord, whether investigation which stage, of course, he is saying.
He can always approach your lordship with another bail application. There is no.
Then
Lordship,
let it come
use
after
the
bail.
CD and take a call, lordship. I am confident about the case, that lordship. So lordship will take a call.
My lord, only I will place some judgment on possession, my lord.
No, lordship,
On
I'm sorry,
possession.
lordship. I'm pressing for a disclosure, lordship, no adjournment.
Let it proceed to some more extent. Let them have some more.
Yes, my lord, certainly, you, my
The
lord.
houses, if the recovery, if nothing relates her to the recovery on the next day, you can definitely consider.
Some decision on possession, my lord, only on possession and that, yeah, my lord. Whole case is but a quick statement. Nothing is there from my house.
At this stage, we are not
That,
inclined to go into
that is up to your
extent.
lordship, matter. I have nothing to
We
say.
are not.
But
Mere-
my
mere-
case is that my
mere
lord,
absence is not a ground, lordship.
huh?
Mere absence of contraband from the possession is not a ground, lordship.
No, certainly, why
Let us
not?
be very clear, lordship, that he is harping on, lordship, no recovery has been made. That cannot be a ground, lordship.
Not from my hand, nothing is there, even Caesar list
That
is there.
is not a ground. That is not a ground in commercial.
But
contract.
Caesar list,
That's
Caesar list is there.
We did not want to comment upon that, sir, but with the operation of this magnitude,
Yes,
one house being raided, the next one being raided after 24 hours,
yes.
to take hours to just clean up everything in that house. We are not commenting on it. But
Yes,
what we are saying is that when you are proposing a possibility, there is another possibility in our head, in our minds.
But that is the presumption,
not-
my lord, that presumption.
At this
only.
stage, sir,
Yes.
I cannot bring myself to grant the bill.
I lift your worship, my lord. That's all. If possible, my lord, it may be on another day, one day for that. My lord, only he is now will not do, my lord. We have also some liberty, my lord.
I am
A
entitled
lady
to
with
make
4 years
myself,
child, my lord.
I am entitled to make myself.
Yes, sir, certainly.
He
Sir.
can seek for time. I can trace.
I'm not saying.
He's not opposing your,
I am
opposing
not
the
opposing
prayer.
that.
Yes.
He's saying that that will not be the only ground for me to reject.
That is what I am saying.
That is what he's saying.
You have a right to say. I have nothing to say, my lord. My case, my lord, one day I may have some judgment on possession, my lord. One day.
But then it has to go to sometime in the 3rd week of February.
Lordship,
If
again,
you say so.
February, my lord.
There is no other option. We are filled up. We have stopped giving dates. We are now requesting him to keep a track of what dates we are giving. January last week filled up.
Lordship, from
First
the,
week filled
I'm
up.
sorry
Second
for,
week filled up.
I'm sorry for interrupting,
He is
Lordship,
here,
but
my
from the investigation point of view, Lordship, it is very
It
imperative.
will not be proper now to release on bail. That we
Lordship.
understand.
So it is
That-
very
that-
imperative that it reaches its logical conclusion,
It's
Lordship,
better if
because
we reject it now and keep the door open for.
I think, my lord, again, the lady is to come again, my lord. So,
Given the circumstances, the intermediate possession, intermediate.
no, that's my lord. You know,
We are not even keeping
You
it.
lost
We are not even.
no, I'm
looking
only
for
on that,
some
my
in
lord.
some cases.
I think that will not prejudice to anybody, my lord. Suppose, my lord, it comes after
It would.
4 days, 5
Her
days.
not being arrested on the first day, and
Yeah.
then nothing. Then her house going totally clean of everything.
No, that is a,
If we
what we
comment on
may assume and presume, my lord.
We have to look at both
No,
these.
that,
sides.
but,
We are trying to look
but in
at
the
the
criminal
innocent part.
jurisprudence, my lord, assumption, presumption will not come in the criminal. Your lordship is aware of that game. I am simply asking about after 4
We are
days.
just trying to weigh
Yes.
the pros and cons of
No,
granting
no,
appeal
no.
at this stage.
I think, my lord, not, my learned friend also will not be prejudiced 4 days, my lord, after immediately after vacation, my lord. How he will be
Lordship, we
prejudiced?
cannot produce the case that he
No,
like.
we are, no,
Lordship,
we
this
are,
is
we
not
are,
an-
we are not in a position to grant a date on 4 days, after 4 days. We have listed around 32 matters a day.
February 1st.
Besides what is coming from the registry itself on the listing side, we are fixing 30 matters a day. Would it be humanly possible?
First day, 2nd February, as your lordship is saying, my lord. Let the city go.
It is only in the second week of February, at best 12th or maybe 13th, not no.
17th,
Not before that.
second week of February.
It's an impossible situation for us.
Date 12.
12th would be the earliest, but
Yes, sir.
Mr. Chaudhary, I think it is better.
My
if
lord,
you reject it
I pray, my lord, because my instruction, I am
12th,
saying
12th.
12, my lord. Let the city goes, my lord, let it come up to date, my lord, I am not on that.
Lordship will make the observation regarding the 48, Lordship, what I have submitted.
Yes.
Yes, my lord.
Chaudhary, Learned Counsel, Learned Senior
This
Counsel,
is
appearing
available
the
in the city,
petitioner,
my lord.
assisted by.
I,
Also heard Mr. B. Sharma, Learned APP appearing in the matter. The CD call for has been received and has been produced. The Mr. H.R. Chaudhary, Learned Senior Counsel, has submitted that the notice under section 48 of the BNSS did not suffice the requirements of law, in as much as the same was
addressed to
the Gaubura of Udina and not to any family, relative or friend of the arrested petitioner. Full stop.
and he is not
The-
related to us. And
That is what I said, family, friend and relative is. The Learned APP has submitted that Learned APP has submitted, and the case diary reflects that the petitioner had nominated the Gaubura to be the person on whom the section 48 notice would be required to be served. And there is also a note that all the other family members were either in custody or were absconding. Would stop it. He therefore submits that it is in those circumstances the person nominated by the petitioner herself was served with the notice. Would stop. This aspect of the matter is disputed by the learned senior counsel appearing for the petitioner, stating that there was no such nomination made by the petitioner.
And till today, notice has been received by the petitioner.
And till today,
She has not received any notice till today.
and till date she has not received. She has not received it.
Not at all.
Under
We made a
47,
statement.
it has not been given.
Yes, not mine.
The learned senior counsel has.
Family members. Her family members is to be received. Ma'am.
Then none of her family members
Yes,
has received.
her
a
family
notice
members
under
to receive it.
section 48 of the BNS.
Yes.
Stuff.
And other than on merit also, my lord. But
On merits, the learned senior counsel has submitted
on the
that
co-accused statement, constant possession is not there.
there is no conscious possession on the part of the arrested accused, and nothing has been recovered from the house on the date on which she was arrested.
Yes.
The seizure list does not reflect any recovery of contraband materials from her home. He has also submitted that she is the mother of a 4-year-old child and thus deserves to be released on bail. The learned APP has objected, stating that the mere conscious absence of recovery from her own house would not be a guiding factor in a case like this. Full stop. The list this matter again on 12th, did we say 12th? 12th of February 2026. Full stop, the CD may be returned and an updated CD may be requisitioned for the said debt stuff. List
Obliged.
Any item? 74 petition.
Interim, consideration of interim, yes.
Yes, Lordship. Lordship, I preferred this petition seeking quashing of the impugned order of charge, Lordship, dated 14/8/2025, whereby I have been charged under section 21B, 8C and 29 of the NDPS Act.
What is your ground of challenge?
Lordship, that charge order has been framed very mechanically and Lordship, I would satisfy your Lordship on that.
No, that expression was because we are trying to find out if there is a case for interim, whether you can make it. You are just making a very general statement, therefore the expression, yes.
I would satisfy your Lordship on that. First of all, if I may place the facts of the case. Lordship, the prosecution's case is that they had information from a source that 2 parcels containing cocaine. Lordship may note down the tracking ID, Lordship, that would be relevant. One bearing number 95 and another one is 97 with the last numbers 95 and 97. It was supposed to reach a courier service, which was at Paltan Bazar. And accordingly, an FIR was lodged. And on the very same day, the officials reached that courier service and they examined the parcels. They found those parcels there and they were waiting there. They were anticipating that someone would turn up and they would claim the parcels. And in the meanwhile, as per the prosecution, a person with a mobile number with the ending 226 called a person of the courier service. And thereafter, 2 persons turned up, one being me, and according to them, we inquired about the parcel bearing number 95, and that parcel was handed over to me, to both of us. And thereafter, it was seized from us. It is their case. And after that, Lordship, they also alleged that we have given them information with regard to 97. And on that parcel, Lordship, it was in the name of a person named H. Das, and the address was given of that person. It was of some lodge, and the number was also given. And on the basis of that information, they again went to the people. They say, we have revealed that it might belong to those people. They went to the house of those two accused persons and then they searched their houses where they found some charas and some amount of Lordship. Now the case is that the entire allegation against me was that 95 packet belonged to me. 97 was not even arrayed against me. Now, if I may take your lordship to the charge.
Nothing recovered in 95. Parcel number 95 did not have anything.
There were 26 pouches of inside. 26 pouches were found inside with cocaine.
Okay.
They tested it then and there for samples, and after that it was taken to their office and they opened it there and. Now, if I may take your lordship to the annexure 3, page number 323.
Page number 323.
Yes, lordship. Annexure 3. Para 6. Here, the entire charge has been framed saying that it appears from the record that there are sufficient grounds to frame charge under so-and-so sections against the accused persons, namely so-and-so. That is the only reasoning given here. They have not cited as to how I am being arrayed in the parcel number 97 as well, which contain 35 grams of cocaine, lordship. 95 at 30 grams and 97 at 37 grams, 35 grams. And that 97, in the 97 parcel had a different name, different address, different phone number, and that person was not even called for, investigated on, or made an accused in this case.
Yes, sir.
And lordship may see the.
Why proceed against her in parcel number
Lordship,
97?
there are sufficient for framing of charge. The court has to see whether prima facie materials are there or not. And a trial court, after going through the materials, come to finding. Lordship may come to page 42. Page 42, role established during investigation, paragraph 61. He is a petitioner, Lordship. Lordship, he is a petitioner. His role has been after investigation that is narrated in the complaint, and the learned trial court, after going through the materials, come to finding. Lordship, may please to see the charge order, Lordship. Because there were 4 accused, Lordship. 2 has filed application and they were convicted and they were released on bail. They were released. Lordship, may please to see. I am reading the page 23. All the page 323.
We have read.
All the accused persons are present, heard the learned persons, and also heard the learned counsel representing the accused persons. Seen petition number so-and-so, which the accused Amit Jain, Deepak Bhatta, and Vicky Amin prayed to discharge them. Heard the learned counsel for the accused persons on the said petition, who pleaded that the accused persons are not involved in this case. Also heard the learned special PP for NCB. Peruse the materials on record. It appears that there are sufficient grounds to frame charge.
What we will do is, at this stage, we admit it.
Lordship already admitted.
A stay is required in this, lordship, because lordship, if I may take your lordship to page number 326, lordship. I'll show 326.
326.
Yes,
okay.
lordship. Lordship, may kindly hear me out this. Lordship, firstly, both of you, so and so, were found to be in possession of 65 grams of cocaine, lordship. Now, lordship, if I may take you to the seizure list.
Yes.
Lordship, may kindly take up page number 57, lordship.
'57.
Yes, lordship. This is the search cum seizure list. Lordship, may kindly see signature of the person from whose possession the article was seized. It was not seized from anyone. The NCB officials opened it themselves. This is with regard to 35 grams, lordship. Thereafter, lordship, may. Yes, lordship.
No, this is the, you have given us 2 numbers, 97 and 95.
97 is the one again, of which
You are not connected with.
we are not even connected remotely, lordship.
95.
This is 97, lordship.
Where is 95?
95 is the next page. Lordship may see that there are the signatures of the accused persons. In the earlier one, you can see that there is no signature.
So you would like to argue that has to be for a quantity value of 30 grams.
Yes, even if it is, yes,
You say that if the trial has to continue, it has to continue against 30
30
grams
grams.
and not against 65 grams.
No, Lordship. And also, Lordship, even if it is 30 grams, it would be intermediate quantity. Here, Lordship may see that the quantity and the value, it says that 30 grams, including the weight of 26 numbers of plastic pouches. Including the weight, Lordship. How could it be intermediate quantity?
It is less than, it is a small quantity, Lordship. And all the accused belong to Lordship, affluent family of the Guwahati, Lordship. And this is the modus operandi operating here, Lordship. And Lordship may please to see paragraph.
No, sir, we are not on the guilt or we are not on whether they can be.
No, Lordship, I'm just.
Nothing of that sort. Whether they should be tried.
Yes, Lord.
For a small quantity, intermediate quantity, or commercial quantity.
This is absolutely not commercial quantity. It is.
And the order by which the charges have been framed.
Lordship may please to see.
It's under intermediate quantity, Lordship. 21B.
So yours is so.
If at all I should be tried, then I will face the trial for 30 grams, and that too should be of the intermediate quantity, considering that the plastic pouches have not even been weighed, Lordship. Even if we consider
Lordship,
1 gram,
there is a judgment to that effect also. If the charge can be amended at any stage. So, Lordship, what happened in
Then
this
what
case?
we do is we stay the proceedings for the time being. Move an application before the learned trial court.
No, Lordship, here.
Put it before the learned trial court that it should be intermediate quantity. We'll vacate the stay, dismiss this proceeding.
Lordship, here what happened on 14/8?
Instead of trying to argue out the entire issue here and us giving a judgment that this is wrong and this is wrong, why don't you tell the court?
No,
that,
Lordship,
sir,
Lordship,
let it be the let us try it.
allow me 1 week's time to file my objection in this case.
What? You admit it's an intermediate quantity.
No, Lordship, let my objection may be filed formally, Lordship. The Lordship that consider it. If Lordship
Stay
think,
till that point of time. When do you want it?
if it is think, Lordship may cause the entire proceeding, Lordship.
We find that the proceedings are under the long section of law. We are required to state.
Lordship, then pass order. I'm recording my objection, Lordship, pass order.
Yes. Heard Mr. Insular and Council appearing for the petition also heard. Strikes equal. Can you consider NCB?
Yes, sir.
Both the councils have been heard at length on the prayer for interim. You say the matter is admitted by which order?
Page 323.
You said that this petition has been admitted by which order?
What's it last order?
Huh?
Petition. Petition. Last order. Admit probably this is second time.
13/10/2025, 12/11/2025, 1/12/2025, and 18/12/2025. It is not the second time. It's not the second time, sir. The Learned Counsel for the petitioner has submitted that as per the Caesar list, the total amount of contraband which could be related to the petitioner's hearing is 30 grams within bracket, including weight of 26 numbers of plastic pouches, whereas the charges have been framed by the learned trial court under section 21B/29 with section 8C of the NDPS Act against the accused persons who are the petitioners hearing. On a query made by this court, the learned counsel for the, on a query made by this court to the learned counsel for the NCB as to whether any steps could be taken before the learned trial court to have the charges amended. The learned counsel for the NCB had prayed to be allowed to file their objections to this petition. Admit the petition. List again on data.
Lordship, 1/12/2012, Lordship is this honorable court passed order. Learned counsel, so and so is present. Scan copy of the trial court records were called for.
If we can just have a solution to the entire matter, if the charges need to be amended and can be done at the trial court stage, we need not pursue this at all. If it is
No, Lordship,
prolong it, then you
Lordship,
prolong.
who will file the application, petition or respondent?
To make a submission before the court, the charge is wrong. The court cannot be blind.
No, Lordship, we cannot say at this stage whether charge is framed. It is submission of the petitioner, Lordship.
Whether charge is framed.
Charge is framed.
Yes.
Yes, charge has been framed.
That is what we are
Says
saying.
20
Charge is framed 21B/29 read with section 8C.
Yes, Lordship.
Her contention is,
Against two accused persons, Lordship.
her contention is 30 grams, including the weight of plastic pouches.
No, Lordship, correct.
Under which section of law should she proceed with? Should she be proceeded against? Just tell us that.
No, Lordship, Lordship, it is the grounds of the petitioner.
Mr. KL, Mr.
Petitioner is to file application for amendment of the charge. Will concede.
So we'll now state, we'll say that the charges framed are wrong. It will not proceed till the
Yes,
charges
Lordship.
are framed.
Regarding that, Lordship, I have no objection. Any order, Lordship, can pass. But my submission, Lordship, at this stage, I cannot.
Was that a reminder or was that a taunt? Any order Lordship can pass.
No,
Is it a
definitely,
reminder to us.
No, Lordship, we cannot dictate your Lordship to which order is to be passed. It is up to your Lordship to pass any order. If Lordship thinks that it is incorrect, then Lordship may pass any order. But at this stage, I cannot concede that the charge is wrong. I am submitting on the record because I have not received any instruction till date. For this reason, Lordship, the LCR was called for by this honorable court.
The instructions would be here perhaps.
Lordship, I am not allowed to go through the record because the court was sitting. Lordship, I'll assist your Lordship from this record.
We'll take it up after 15 minutes. Would you like to go through?
Lordship, as per
We'll
your
permit you.
Lordship. And Lordship,
Okay, we'll pass
another
on.
thing, there were 4 accused. Lordship, please to see paragraph 9 of order date page.
2 of them have been released.
2 were
Released.
on the other hand, when the court was about to frame charge against the accused persons, namely Vicky Amin and Deepak Bhatia, from whose position 533 grams of charge were recovered, while petition bearing guilt of the offence under section 27. They were convicted for 50 days and rupees 1,500. And Lordship, Lordship, please to see, there was a.
While we were dictating the order, you told us that the trial court records were called for. We showed you the trial court records are here. What would you like us to do now?
No, Lordship, allow me some time, Lordship, so I can file my.
What I have recorded.
Lordship, there is no problem.
That is what I have recorded.
Lordship.
Let's wait for some time to file their objections to the petition. Okay. List again on data. 6 allowing Mr. KL to file his objections to the petition. In the interim, the proceedings to the learned trial court shall remain in abeyance. The respondents would be at liberty to pray for vacation of this order in case they can show. In case is their case, and to pray for vacation order on the next date fixed.
Much obliged.
Lordship, in this case, I may be allowed few days time to file my objection. I have taken consent from the petitioner.
Heard Mr. Swansula and Council paying for the petitioner, also heard Mr. SC. I have heard you, but they cannot write it down.
Lordship, what happened,
Change of table.
in morning, they didn't allow, given their consent. Now his senior has given consent to, that's why Lordship,
Which one? This matter?
yes, Lordship, 60.
Heard Mr. Swenson and counsel appearing for the petitioner, also heard Mr. Ezekiel, learned counsel appearing for the NCB. Mr. Kale has paid for 2 weeks for accommodation. Will be allowed to file the written objection. List again after 2 weeks of schedule. 18 February 2026.
Much of.
Maybe resolution. Yesterday, Lordship, I was argued, Lordship, on the ground, Lordship, arrest memo, Lordship, section 36, Lordship, violation. Lordship. Lordship, the arrest memo is on page 31, Lordship.
Initialization already. One correction. Number of corrections 1 D 3
31, Lordship.
You look more.
Page 31, Lordship, there is no signature of any independent witness, Lordship. Either from the family member, either or any
Arrested where?
arrested in the police, railway station, Lordship.
Okay.
No independent witnesses there, Lordship. And
Yes, sir.
yesterday I was also pointed out one thing, Lordship, regarding the notice of under section 48, Lordship. Notice under section 48 was given to Arup Busami, chairperson of Thana level Nagarik Committee of Panbazar.
We remember that.
But at this stage, Lordship, I have already submitted, Lordship, bail orders of coordinate bench, Lordship, wherein in commercial quantities charge sheeted matter, Lordship, NDPS Act, Lordship, bail was granted only sole ground of section 36, Lordship, violation of section 36, holding that the provision of section 36 BNSS, it is flows from Constitution of India, Article 21 and 22, Clause 1, which is related to directly fundamental rights of the petitioner and should be followed strictly, Lordship. And the provision laid down in BNSS, Lordship, section 36 B, Clause 1, Lordship, states that the arresting authority shall prepare a memorandum of arrest which shall be attested at least one witness who may be the relative, a family member of the arrestee or any other respected person of the locality. And Lordship, section 62 of BNSS states that any arrest strictly made to the Sanhita, Lordship. No arrest shall be made except this Sanhita. Section 62, Lordship.
Okay. Yes, sir. Anything else?
Yes, Lordship, and the bail orders, I am relying on, Lordship. Three bail orders I am relying on, Lordship. In commercial quantity. Yesterday I have submitted, Lordship.
We have 2. You have to give us the third.
Yes, Lordship.
Amirul and Abu Sama.
Yes, Lordship. One more, Lordship. I want to submit, Lordship. The Amirul one is the recent, Lordship, most recent.
Okay.
Dated 2026, Lordship. So all these 3 bail application was granted by the respected coordinate bench, Lordship. Only on sole ground of section 30, violation of section 36, Lordship. After scrutining
Electronic supply of these notices has been dealt with by the Supreme Court now.
Yes.
It will not be, it will not count.
This is different, Lordship. This is the arrest memo.
I'm just.
but electric supply of for section 48 notice that can be sufficed, Lordship, because sometimes relatives, the address is so far that cannot be communicated physically, Lordship. But in this case, Lordship, even 48 was not served the family.
Yes.
also. Even though electronically also.
Electronic.
Regarding 48, Lordship, whatever is there in the record, I cannot go beyond that. So if Lordship is inclined to pass order on that, Lordship, then I will not make submission on 36.
48, so far, if there is nothing on record to show that the 48 notice has even been initiated to the
No.
relatives.
No.
And it was
probably-
never sent.
Yes.
Then everything goes.
Yes, that is the,
That part already goes.
because if 48, if Lordship kindly takes up, it was given to the.
48 is what we find here. 48 is here.
Yes, 48 is here. It was
48
given.
I have annexed,
Orup
sir.
Goswami.
Huh?
Orup Goswami.
48 is here. Now 47.
47. 47, listen.
No annexed.
47 you say was never given.
No, 47 I have,
You have not raised the ground of 47.
no,
You have received
I'm placing
47.
48 and arrest memo, Lordship.
So 48 is served upon Orup Goswami.
Yes.
Now, unless, like the earlier case, unless you can show me that that was the nominated person,
Yes.
then 48 becomes 48 is violated.
Valid.
So far as 30 something is, what do you say, 36?
Yes, Lordship.
What I'm proposing is, Lordship.
If in a police station, or if in a railway station, not one responsible person is available.
Yes. Of the, it should be a relative or a known person of the locality. By locality, probably it means the person where the accused resides.
Wherever he is being arrested,
Yes.
it cannot be of the locality from where he belongs.
Yes.
So the moment you say he is being arrested in a railway station,
Yes.
any government person who does not have a disciplinary proceeding case or a anti-corruption case against him would become a responsible person.
So probably, Lordship, what I am proposing is, Lordship, I will go to the record once again. After 10 minutes, Lordship will take it up. Regarding 48, Lordship, I will see if there is any entry that she has nominated the person.
She has asked that, please
Yes,
inform me.
then I will
Or
proceed to 36.
that is one part, and the second part, why nobody from the police railway station?
Yes. Because my argument regarding 36 is totally different. Lordship.
What?
That it is not a procedural lapse, Lordship. The intention behind 36 was totally different. That I'm going to show.
That the person should not be arbitrarily arrested or shown arrested later on.
Yes,
Therefore,
specific.
Exactly what we are saying. You are exactly that will come in, because if the person is being arrested in a railway station, not one responsible person signing it.
Yes.
The arrest is a farce.
Not for that, Lordship, it has to be the arrest 36, the violation of 36, signature of any attested witness. That is not in resonance with 21. That is my submission, Lordship. That cannot be held to be a violation of 21, Lordship, as per the DK Basu guidelines. That is the limb of my submission.
But if you have argued it before some other court and it has been rejected, don't do it here
but
again.
yes, that is why.
Then don't do it again. Can we go beyond that?
Yes, Lordship can always go beyond that. Lordship is not bound by the coordinate bench statement. Lordship can hold a contrary view.
And send it
to the division bench. So that was my submission yesterday, Lordship.
10 minutes, just find out
yes.
48. If it was the nominated person or not, we will not touch 36.
Yes. That is what I was
We will leave it open for an appropriate case.
That is what I was submitting with.
May I please, Your Lordship? Yeah, FIR, Your Lordship will find at page 10, Lordship. I have also given a type copy of the FIR, Lordship, because it was not legible and due to clerical mistake, it could not be annexed.
I did not get you. What did you say?
Due to clerical mistake that I could not annex the type copy, Lordship, I have
Of?
given of the FIR, Lordship.
At page?
Page 20.
Page 20.
Page 20.
Page 20.
Font is small, so I have given extra copy. If it is not there, I can hand over.
We don't need it. We were just seeing. There is no objection to it by the registry.
No, to the Lordship, when I moved for motion, then I have handed over. Because it is difficult to read page 20, Lordship.
Please read it.
Lordship. With reference to subject cited above, I have the honor to report you that on 16/8/2025 at about 4 p.m., an information has been received from a secret source that one vehicle being registered number AS01FX so-and-so has been carrying with huge amount of illegal cash money, different banks ATM card and illegal documents, etc. from Dhing side towards Bori Bazar side. Accordingly, made an entry in GD White Bori Bazar PP GD entry number so-and-so dated so-and-so and informed the matter to the OC of Mikirveta PS and instructed me to arrange a sudden Naka at Silpukuri Dhing to
Yes, we have read it then.
Lordship.
We have read it.
Lordship. Here, Lordship, I am not named in the FIR, Lordship. I am apprehending only because of the reason that my brother is arrested in the present case. That your Lordship will find at page 23, forwarding report. That Rosidul Islam, son of Jamir Ali, relevant person, page 24, is name of arrested person.
Page 24.
4. Down below your Lordship will get Rosidul Islam, son of Jamir Ali. He is my own brother, Lordship. Now police is repeatedly calling me to the police station and threatening to arrest. Therefore, I am apprehending arrest before your Lordship.
Does the police actually do that? Call you and then threaten you that I will arrest you? Or
Sometimes they call at night, Lordship. That itself shows that they are going to arrest me, Lordship.
They never inform you before arrest.
Lordship, their conduct sometimes is Lordship.
They always say, please come over, we have to discuss.
Lord. And the present petitioner is driver, he was.
Absolutely, he is imperative for solving the case, Lordship.
And he was working as driver in Kuwait, Lordship. That some documents I have annexed as annexure 1, Lordship, page 10 onwards. He returned to India in 24 September, Lordship, to his home. Prior to that, he was in Kuwait, Lordship.
And now what does he do?
Driver, Lordship. He was working as.
Now he's a driver. Now.
Now, Lordship, he was at home, Lordship. Now he was riding private vehicles, Lordship, in his local.
Anything in the.
Yes, if he has finished, Lordship, answer.
Yes, he has finished.
Here, Lordship, the first thing is, Lordship, Rosidul Islam, who happens to be his brother, he has implicated his own brother. First. Now, Lordship, this involves cyber crime, where the cyber crime activities from all over India, the targeted persons, from their money is taken, Lordship, through online mode and it is deposited in some mule accounts. Those mule accounts are operated by a gang, Lordship, including this person's Lordship. And the volume, Lordship, it's a very interesting read. If Lordship kindly peruses the case there, I'm just pointing one thing, Lordship. In one of the account that has been seized as of now, Lordship, belongs to an Axis Bank account in the name of Google India Digital. There, Lordship, the amount total deposited is around 4 crores. And transaction is upwards of 100 crores. And in this account, Lordship, money from all over India, from persons duped from online transaction, online fraud, those accounts, this is only one account, Lordship. There are several accounts and several co-conspirators are yet to be arrested, including the present petitioner, who happens to be one of the main persons, Lordship. His own brother has implicated him. And this is only one thing, Lordship. In the accounts, Lordship, daily around 1 lakh rupees are deposited. Subsequently, it is withdrawn from the co-accused, Lordship. Around from one co-accused, Lordship, around 40 to 50 ATM cards have been recovered, 7 or 8 pen cards. They have identification paper of one authority in different person's name.
At
So,
this stage, sir, no.
No, Lordship, what
absolutely-
my submission to your Lordship is that they may show any material to my involvement, Lordship. There is co-accused statement that I admit, Lordship. Just one
The
citation I am
accounts which are open,
Lordship,
there is a term called identity theft.
Lordship. There are accept,
So
but
therefore, nothing will be directly linked to you.
no, if anything they have found, Lordship, because just one thing I am placing for
The statement of the brother is what they find against.
just one paragraph of the judgment.
Other co-accused also.
That regarding Lordship, if they object to a bail application, Lordship, they have to show prima facie material, Lordship, regarding that, Lordship.
But the bail application will consider it. If no privacy material, they say.
Because if
they say that
brother
will
was
consider-
arrested and how these statements are recorded, that your Lordship know, that but if any other material they have found involving that regarding that procurement of or
Economic
opening
offenses,
that bank
economic
account.
offenses break a nation. Careful.
Because other persons are involved, that is, they are in the FIR and forwarding report
All
also.
the co-accused, Lordship, they have named each other, including the present petitioner, and Lordship is very well aware that in the investigation state, 161 statement can be taken into consideration. That is the basis of investigation. And in this type of investigation, Lordship, where cybercrime is involved, Lordship, custodial interrogation is utmost necessary, Lordship. Otherwise, everything goes.
Mr. A. Madam Council opinion for the issues with and also Mr. Vishwaman. The case diary is called for this being. Receipt and produced. Given the initial stage of the nascent state of investigation and the materials on the case diary, at this stage, this court is not inclined to grant the privilege of pre-arrest bail to the petitioner. Accordingly, the prayer for anticipatory bail at this stage is not acceded to. Anticipatory bail petition stands dismissed. At this stage. Let's have
Obliged.
investigation take place.
Are the numbers 39?
Yes, sir.
In item number 39, case diary was called for. In the meantime, charge sheet was submitted. On the last occasion, there was a direction from this honorable court to take instruction regarding my whether my name appears in the charge sheet or not. I am on interim. The instruction has been is pending.
What are your names?
Anjumani Bhuiyan, Deepak Shah, and Lakshman Kumar Yadav.
What about this other two bail and ABs?
So was submitted a search sheeted by Margarita PS case number CS number 145 2025 against the accused person, namely Raja Rai, Jitu Gogoi, Zit Bahadur Thapa, Ravi Gupta, Umesh Kumar Sharma, Chiranjeev Kumar Yadav, Debo Chaudhary, Ranjit Nath, Bitu Gupta, and 10 Dhanti Buragohai.
These are the persons.
These are the persons.
In item, in this case, item number 39, my name is not appearing. I'm on interim, but my name doesn't appear in the charge sheet.
You don't need to then
Don't need to go and appear.
appear where?
For bail, it's
Appear for what?
nothing.
If your name is not there in the charge sheet, where do you want to go and appear?
No, no, no. This in item number 39, my name doesn't appear, but in item 68, my name is appeared. Jit Bahadur Thapa is.
That you will see. Let us close this.
68 next.
The heard Mr. Swensel and the council paying for the petitioner also for the letter by the last order. The APP was required to take instructions as to whether the present petitioners have been named in the charge sheet today. After going to the charge sheet, the learned APP submits that the names of the present petitioners in AB number 2890, namely Anjumani Bhuiyan and Deepak Shah, do not appear in the charge sheet and they are not up for
One
trial.
more name. Three petitioners. Lakshman Kumar Yadav.
And Lakshman Kumar Yadav. Three names are there. Are not put up for trial. Accordingly, there appears to be no reason now for the petitioners to apprehend, arrest in connection with the present case at the present stage. Stop. In the present state, full stop. Accordingly, anticipatory bail petition is closed. Yes, what about this, sir?
In
What do you
this
want?
case, I am not on interim lordship,
Ah.
so I will apply for regular bail.
Ah.
And appear before the trial.
The case diary has, the learned, heard Mr. So-and-so learned counsel for the petitioner also heard the learned APP who has submitted that the charge sheet has been submitted in the present case. The learned counsel for the petitioner prays for the liberty to the petitioner to approach the learned trial court
And
to pray for regular bail.
And the trial court shall consider in accordance.
And the liberty prayed for is granted, trial court shall consider any bail petition filed before it without, on its own merits without reference to the closure of the present anticipated bail petition.
White CS number 145/25 dated 31/12/25.
That charge sheet number, no? Yes, charge sheet has been submitted, I said somewhere, no? Charge sheet number is giving.
Charge sheet number 145/25 dated 31/12/25.
Wait, your lordship. Here petitioners are on interim bail lordship. As per my instruction, they appeared before the investigating officer lordship. And page 10 is the FIR.
Recorded, statement recorded.
Statement as per my instruction, it is recorded, subject to what my learned friend says.
You are appearing, sir, for?
Lordship, today we have filed a Okalat Tama Lordship, for the in behalf of informant Lordship. In this case, Lordship, subsequent development is there, Lordship. I was just, if Lordship directly, I will put on record by filing an affidavit. After getting the interim bail, Lordship, they have written the family members of the informant as well as the informant, Lordship. To that regard, Lordship, we have filed a complaint in the police station. And that has been investigated by IO Lordship, by Inspector Lordship, and he have given a note here, Lordship. He says that after verifying the spot, it was found genuine, witnesses were also found, due to the court cases, this has been done.
Moreover, lordship, there the eyewitnesses are also there, who have seen these two
The
persons.
allegation is they have broken into the shop.
Lordship. The
Accused
witnesses.
person broke into the informant's furniture shop. So someone saw them at night breaking
Yes,
into the
yes,
house,
lordship,
breaking
yes.
into the shop and taking away 3-4
Lordship,
lakhs.
witness statements are there. And interim was granted without looking into the CD,
Yeah,
lordship.
that is.
Lordship. Lordship may look into it, I have it, lordship.
I don't know. First page is the complaint, Lordship, and second part is the investigation report. That is in Bengali, Lordship, I have to tell you. The report, Lordship, they looked into.
This is the Bengali part is the FIR.
The
complaint.
Subsequent complaint.
Ah.
That they have written, and that the second page below, Lordship will find the findings of the investigating.
Second party is the accused.
What is the dear,
accused
lordship?
very-
Clear eyewitnesses, dear lord.
Inside your lordship, there is the FIR and some other documents which I have enclosed with the petition, lordship. Lordship may kindly say page 10, your lordship has seen the contents, lordship. Now, lordship may kindly say page 11, the description of
11.
schedule. Page 11, lordship.
Yes.
That is description of schedule length. Should I go further or because lordship, he has
that
given
may be-
some FIR, lordship, that regarding that I have no instruction and I have no knowledge about that. Lordship. So if your lordship goes further, that may, lordship, I may obtain instruction from my client regarding that FIR.
Lordship, here I want to state here, lordship, there may be land issues, that is a different issue, lordship. But in this case, the criminal offense is there, lordship. And regarding to that, there is an.
Your the police report does not say that something has happened in between. after the interim order.
That lordship, that is incident 17 lordship, 17, 12 the complaint was given and thereafter the inquiry was on 19 or.
Yes, you want to have your instructions?
Let him put it on record, Lordship.
Huh?
He may put it on record by filing affidavit, Lordship.
With the violation of the interim
Let the
order.
CD be brought on record.
No, he, that FIR, which he have filed.
But in the CD, it is not there, Lord.
You filed your wakalatnama here.
Today actually, today.
Is that the procedure in a bail petition?
Lordship?
The party is state of Assam.
No, for informal lordship. Prior to permission lordship, for informal lordship.
From whom?
To know.
No, no,
bring up
no.
the lordship, this subsequent development lordship.
For whom have you filed the wakalatnama?
For informal lordship.
When he is not a party in this case.
No, informant, sometimes we give this one to assist the PP lordship.
Give the wakalatnama to him. Why are you filing it here?
No, but we have to file the signed by the informant.
Normally one application is required, but.
There should be an application either to the PP or to us. Please allow us to assist him. Huh?
No, we have taken.
How can you have an how can you take the wakalatnama on record?
Normally we do like that only, lordship. We informant gives wakalatnama, we file the.
This will be like saying normally something is some non-commercial quantity is found, it is not done.
Only to bring the subsequent development. Otherwise, lordship, everything will be the case that I cannot say the matter from case.
Produce the contents of the CD as produced by the learned APP. On instructions from the informant has assisted this court through the additional PP by submitting that after the petitioners were granted an interim protection, they have acted in a manner in which the informant had to approach the police authorities and this was a full stop. There appears to be a report by the officer in charge of the Sri Bhumi PS, full stop, learned APP would take instructions on the submissions made by Mr. Swenso, who puts in appearance for the informant. This again on
Any date, Lordship.
any date. Please.
Return lordship, that part comes in the case there, lordship.
That is what I've said. With instructions on your submissions.
There is certified copy lordship.
Interim order is there.
Interim order, interim protection granted to the petitioners to continue to till then. So it is made clear that the petitioners shall not indulge in any coercive action against the informant as complained by the learned counsel for the informant. Yes.
Obliged, Lordship.
Anticipatory bail application, perhaps case diary is not available.
Yes.
I'm otherwise on interim matter.
It is not available.
But Mr. Swenso, learned counsel is paying for the petitioner. Learned DPP submissions that case diary is yet awaited.
I'm on interim.
List again on.
Interim.
20 February 2026.
I'm deeply obliged.
Interim to continue.
Police case charge sheet submitted.
In 42, I was an interim, I appeared, my statement had been recorded.
Charge sheet
Charge sheet has been submitted.
I was an interim, I appeared, and 43, the petitioner is a driver and they are in custody, In that case, Lordship may direct us to apply for regular bail.
The heard Mr. Swenso, learned counsel is paying for the petitioner.
But in
also
40,
heard
Lordship
the
may make it
learned
absolute, because we have appeared.
learned APP who submits that the charge sheet has been filed in the present case. Full stop. The learned counsel for the petitioner has submitted that Pursuant to the directions of, pursuant to the interim protection granted by this court, the petitioner has already appeared before the investigating authority and cooperated with the investigation process. Stop. We are above the interim protection granted earlier is made absolute. Anticipated bail petition is disposed of.
Yeah, we will apply for regular bail.
Huh?
Yeah.
Item 43.
43.
Heard Mr. So-and-so and counsel. Also heard Mr. So-and-so and
Charge number.
But in the other one, you take the charge sheet number. I forgot to do.
This is 97.
Charge sheet has been submitted by charge sheet number 97.
Stroke 25, dated 23/12/2025.
Item 43, you take down. Heard Mr. So-and-so. Also heard Mr. Also the APP who has submitted that the charge sheet has been submitted by charge sheet number same रहेगा, dated same रहेगा. Stop. The counsel for the petitioner pays for liberty to approach the trial court to pay for regular bail. Bail application is closed with the liberty as paid for.
Oblige, my lord.
postmortem যদি আগে ক'ব আৰম্ভ হ'বই না मतलब the case that you are sought for, my lord. मतलब very unfortunate, my lord. A lawyer friend, my lord, his relative has gone from Mother Earth, my lord. Case of suicide. In this case, my lord. So many of my friends are opposing, my lord. Now today is for hearing, my lord. Now what has happened, my lord? Whether the diary is absolutely complete or not? Because meanwhile, if he says, my lord, that a postmortem report is not there, then again, my lord, it has to be postponed or, my lord, to that effect.
With all respect to Lana Senior, my lord, yes, postmortem report is not available. Inquest report is there. But the question is, my lord, regarding my lord, that is not under dispute, my lord. Even the father, my lord, the informant of the girl, my lord, he also said that yes, it is a suicide. Regarding suicidal, it is not disputed. Only, my lord, abatement 108. Something has happened on the
lady who expired.
Yes.
How is she connected to this person?
My lord.
Because allegedly she committed suicide, my lord. I don't know. This is a stand taken by my friend. Is contrary to everything, my lord. In every case, when the postmortem report is not there, but this is the norm, my lord, that the postmortem report need be there, my lord, that to be diary to be complete. As to whether earlier 306 and presently, my lord, with all respect, my lord, 108 of the BNS, my lord. If, my lord, without the postmortem report, full-fledged hearing should take place, my lord, I am ready, my lord. Up to him, my lord. Question of assault is there, my lord. Lady allegedly committed suicide, my lord, because she was allegedly having an affair with somebody else. That boy was with him along with the lady, my lord. Have I made my position clear, my lord? That the injury on the lady, it has to be, my lord, with all respect, proximity in time.
Stop. The CD, though received, does not contain copy of the suicide letter allegedly written by the deceased and the copy of the postmortem report. Establishes matter again on 29th of January, as suggested by the learned APP, on which date the investigating authority shall ensure that a copy of the suicide note shall be made available to the learned APP, failing which he may be required to be present in the court. Should we record that or?
We'll bring them.
Shall ensure that a copy of the suicide note is made available to the learned APP for production before this court.
My lord, my lord, highly obliged, my lord.
দাস মই খবৰ পাইছো ৰব
Yes.
এতিয়া দিব এতিয়া মোক
In the
ভিডিঅ'ত
It is available.
Who is on video? Oh, Yeah, আমার volume to 0 করে দাও, আমার volume to- Yes.
And the if there is available, petitioners number 5 and 6 are on interim, my lord. A fight took place, my lord, that party is admitted. Injuries were sustained by some of the victims, that part is also not denied. 2 FIRs were lodged, my lord. One FIR was lodged against us, in which we are seeking bail, and another FIR was also lodged by us. First, your lordship will kindly come to the first FIR.
Yes, 2 persons have had their statements recorded.
Yes, my lord. Petitioners number 5 and 6, my lord. They are the women folk, my lord, the ladies, so they were granted interim, my lord. They have appeared and cooperated.
Yes, what will you?
Yes, lordship, here the injury report is there. And to one person, Sikdar Rahman lordship, it is in the FIR also. He has sustained lordship grievous hurt. And I have looked into his statement lordship, because he is the injured person lordship. And he has clearly implicated this person. All these of this person's lordship.
Including the ladies.
Lordship. He has need. And moreover, the other injured persons are also dear lordship. Though they are a simple injury as our dear lordship, as the injury report, their statements also all have been implicated lordship.
6 persons, my lord, they have
Now,
allegedly,
Named 6 persons lordship.
allegedly 6 persons ganged up.
injuries are there, everything is there. If you have got all the statements and the evidence, why the custody is necessary?
So otherwise lordship, but the materials are there. Against these 2 persons, I don't know lordship. This is a lady. But against other persons, they are not given interim lordship.
We have also
Otherwise
lodged
lordship.
we have also lodged an FIR, and our FIR has also been lodged under the same provisions of law, my lord, because we have also sustained grievous hurt, my lord. That FIR is also under investigation. Now, the question is, who were the aggressors in the fight, my lord? That is one aspect, my lord, only in the trial it will come up. Just for now, both cases are under investigation.
That may. Otherwise lordship, but materials are there.
Materials is given custodies.
Lordship, lordship.
But Mr. Swanson and counsel are paying for the petitioner also, but Mr. Swanson and APP. By the order dated 8/1/2026, this court had granted interim protection to the petitioner number 5 and 6 in this petition, requiring them to cooperate with the investigation. Most of the petitioners number 5 and 6 have apparently have appeared before the investigating authority, and their statements have been recorded. The case diary has been received by the GPP and has been received by the additional people. First up.
Lordship, one thing I need to clarify, lordship. Here, one in the last page, lordship, I have just seen now. Part charge sheet has been submitted against Aklima Begum and Asma Begum.
These 2, my lord, who have been granted interim, perhaps for them.
But I have seen lordship just now. They have been part charge sheeted lordship there. These 2 persons. Charge sheet has been submitted against this.
It is submitted that the charge.
But number I have not
Charge
found.
sheet has been submitted against the aforesaid 2 petitions.
To this petitioner, lordship.
Two
Lordship.
petitions, first up. In such view of the matter, the interim in protection given to the respondent to the petition number 5 and 6 are hereby made absolute.
Absolute.
Charge sheet.
But numbers
Any
I
number?
have not found. Number I have not found.
Number
It is
number.
only stated that lordship. But charge sheet did decide.
Since having gone to the Israeli this court is that the petitioners number 1, 2, 3, and 4 also deserve an interim protection. What do you want to do? You want to bring a updated CD? You are given a part charge sheet, not against the others.
Lordship. The part charge sheet has been given against these 2 persons. Again, this person has not been, other 2, 5.
Because, my lord, we have not appeared. so
Not
far.
appeared, lordship.
The petitions number 1, 2, 3, and 4 may be also be granted an interim protection, allowing them to appear before the investigating officer to have their statements recorded accordingly. Para 7 of the.
Accordingly, it may be disposed of then, lordship. Accordingly, it may be disposed of, lordship. If interim.
Will appear, my lord.
Appear.
Allow that. Interim protection accordingly it is directed that the petitioners number 1, 2, and 3, 4, 1, 2, 3, and 4 in case of their arrest shall be released on bail on punishing a bond of ₹25,000 each with one share amount subject to the satisfaction of the arresting authority and subject to the following conditions that one will be applicable to them. Violation of any condition shall entail cancellation of the bail. Stop. It is made clear that the petitioners number 1, 2, 3, and 4 shall appear before the investigating authority on or before the 6th of February 2026, failing which the protection granted by this order shall remain lapsed.
I'm deeply obliged.
Bail application disposed of. Yes.
Very big lordship, there's 17 petitioners, petition number 1 is an interim.
How many?
17.
17.
There were group clash, okay, case and counter case, on the same day, our FIR is a page, 15. On the same day, we launched the FIR, our cross case. On the same day, we lost the cross case.
What happened to the statement by one?
One is it,
1912, no?
Why were the rest not considered?
Because grievous injury is there,
Investigation is going on, and as per the injury report, one person lost one finger. One person has cut injury, both are grievous. And petitioner number 1, though got interim, he Habibur Rahman, and petitioner number 7, Sukur Ali. These are the person who blow by dove.
Who came with the dove?
Who gave the blow.
Acha.
And other persons also assaulted. All are involved. As per the statement of the injured, there are photographs. Cut by one finger, one person got injury in hands, and all are involved.
Lordship comes to page 45, the bail order. Page 45, bail order.
45.
Regular bail order. The cross case lodged by us, charge sheet, the lordship found page 6, paragraph 6. And there's one observation in paragraph 7. It appears that there was a quarrel altercation between two groups, wherein some of the persons from both the groups sustained injury. So it was a free fight between both groups. So the concept of vicarious liability cannot be applied.
This is regarding whom?
This is regarding FINM accused number 3 and FINM accused number 13.
Your informant or their informant? The other side.
84, item number 84, supplement.
Our co-accused.
We'll do it right now. We'll take it up on the first item.
In the institution that I was seeking bail, they are FINM 3 and FINM 13. FINM accused number 3 and FINM accused number 13. The bail order.
Yes, others have been granted the bail.
That petitioner number 1, only because of his age, interim was granted.
That is
so far my knowledge. But he is fully involved. Petitioner Habibur Rahman is the victims who got injury.
The bail petition
AB. Petitioner who injured he got injury. He himself took the number, and Habibur Rahman names is at serial number 1 as per the statement of the injury.
Let us be protected with face trial because our case has been charged sheeted. And in a fee fight,
in your case, it has been charged sheeted.
Yes,
in the FIR filed against these persons.
Yes, we filed an FIR against the informant side, that has been charged sheeted. Our FIR is a page,
This may also got charged sheeted. Injury report is there.
We'll face trial, it is a joint trial, case and counter case, We're not running away, The quarrel took place because of that sandbar land, they wanted to occupy it,
Allow them to appear. Let them go and appear. 17 of them. How many of them?
Yes, 17.
17. But specifically regarding 1 and 7, Sukur Ali and Habibur Rahman. Habibur Rahman, those 60 only showing the age interim was granted. That is there. But
involvement I am saying, matlab,
He is more dangerous.
maybe other persons are, all are matlab, assaulted by lathi and all these. Matlab, by giving dow blow, these two person. One and
No, one has already had his statement recorded.
Yes, yes, we have, as per instruction.
Intergroup fight. If you like to prolong the investigation, it is up to you. But Mr. Swenson and counsel appearing for the petitioner also heard the learned APP appearing in the matter. The petitioner number 1, who had been granted interim protection, has appeared before the investigating authority and his statement has been recorded.
Well,
Full stop. The learned counsel for the learned APP has submitted that as per the case diary, that's petition number 1 and petition number 7 appear to be involved in causing grievous injuries by sharp weapons, and the other petitioners appear to have engaged in the group clash. Leading to injuries on both sides. Learned counsel for the petitioner submitted that in the cross FIR filed by the
informant side, petitioner side.
by the petitioners. Petitioners, comma, the same has been charge sheeted.
Yes, ma'am. It's reflected in the order, ma'am.
And some of the accused involved therein have also been granted bail.
Regular bail.
Full stop, regular bail, full stop. The in view of the circumstances, this court deems it fit to, this court directs that the event of the arrest of the petitioners number 2 to 17, they shall be released on furnishing a bond of rupees 20,000 with one surety of the like amount to the satisfaction of the arresting authority, subject to the following conditions. 1, 2, 3, 4, yeah, power to by DTO. It is further provided that the petitioners number 2 to
16 million.
16
2
shall
to
appear
17
before
million.
the 2 to
17 million.
shall appear before the investigating authority within a period of 5 days. Don't say 5 days, say shall appear before the investigating authority within 31/2026 to have their statements recorded. For the continuance of the interim protection will be considered on receipt of the updated case diary. List again on
23rd
February.
20th February.
Obligement.
My objection. One line.
Objection to fighting.
Obligement, highly
You
obliged.
said that you pointed out that they have a DAO and they are striking.
Obligement.
Item from correction list for withdrawal, item 1.
And counsel for the petitioner has submitted that he is under instructions to not to place this bail petition in his present form because
Already has it submitted.
in his present form and he may be given the liberty to approach the learned trial court pray for regular bail. Bail application closed with the liberty as paid for.
48 for orders.
And then the order.
May I please, your lordship? Lord, in this case, Lord, co-work is already granted bail by your lordships.
Huh?
Co-work is already granted bail by your lordship, Lord. I have the order, my lord.
This is a criminal appeal.
In IA, lordship.
Can I do this?
IA is their lordship. Why not? Same footing, lordship. One co is already granted by your lordship, bail, lordship. So, my lord, I am praying similar order, lordships.
In the same case?
Lordship, same case. 2 accused convicted, 1 lordship granted bail. I am, my lord, inside the jail, lordship. So, I am praying so similar order, lordships, on the same ground, lordship.
Heard Mr. Swenson and counsel appearing for the
7 years. 7 years.
counsel appearing for the public applicant. Legal counsel for the applicant submitted that a co-convict has been granted the benefit of
Objection may be recorded.
has been granted the has been granted the benefit of suspension of the sentence passed in the judgment and order dated so and so. Stop. Special PP and the additional public prosecutor have objected to the bail prayer. Stop. That's what we have perhaps 6 to be. Oh. আহিলে নেকি পুলিচে ৰেকৰ্ডটো যে কল কৰিছিলে নাই আহা ন প্ৰডাকশ্যন হৈছে এইটো আজি কাৰণে ফিক্স আছিল দেখোন আজি কাৰণে ফিক্স আছিল লোকৰ ৰেকৰ্ড অহা নাই ন
Bottom must take lordship. Bottom it has take lordship kindly.
The lower court records have already been called for in. What is that appeal? What is the other appeal number?
Criminal number not here lordship, but IR number is dear lordships. By bail of granted lordships. I have placed the order lordships.
This IA has been disposed of.
Lordships.
By keeping the.
Lordship, yes, lordship.
If you want to take it together, you have to give
No,
us
lordship,
the
not
appeal number.
Not recorded.
IA disposed of. A criminal appeal to liquidate. Lower court records have not been received. List after. A list on 25th of February 2026. Awaiting lower court record. Yes.
49.
এইখিনিয়ে নে ইয়াৰ পিছত আৰু আছে বিচিত আছে কোনটোত আছে এতিয়াতো ভাল হ'ব নেকি Yes.
May I please, Your Lordship? Lordship, this is an application for suspension of sentence. On the earlier order, a report was sought for from the office of the PP regarding service of notice. However, we have come to know that in case of 376, notice to the informant is not necessary. So a date may be fixed for hearing of the I.
For suspension of this thing, why don't we take up the list this matter again on? When do you want it, please?
My lord, 28th of this month.
Not this one. Not this one.
Then 9th of February, my lord.
For orders, for hearing it.
For others.
9th of February 2026.
Item 50. On the last occasion, notice was issued in this case, Lordship.
He has not issued any.
Notice issued on the respondent number 2 has a service of notice. Report of service of notice on the respondent number 2 has not been received as of yet. List again on service report.
13.
13th of February 2026, awaiting service report.
Hearing matters. 51.
Not be possible now. Can it be fixed on 7th, my lord?
7th of February. 7th. Let him see if there is some scope.
7th is now, my lord, it's opening, my lord. First Saturday and third Saturday. Though probably.
Who will build the cat? Should I build the
No,
cat?
bar. There is a meeting in the bar. So for this matter is concerned tomorrow. But since already my lord has fixed the matter.
No, since we will be only opening on this first,
10th,
for the first time.
10th,
For the first time, we do not want to.
And anyway, my lord, let it not go into that area, my lord. Let it fix on 10th, my lord.
10th of February?
Tuesday.
10th of February.
This matter again on the 10th of February, since paucity of time does not allow the matter to be taken up today.
52.
My item is effective.
Lordship, this matter will be fixed on 13 February.
13 February.
13th February. 13th is Friday, not possible. 17th February.
7th.
This is matter again on the 17th of February 2026. Since paucity of time does not allow the matter to be taken up today.
53 by VC mode.
Matter may be fixed on 10th of March, Lordship. And there is an interim order, Lordship.
Place this matter again on the 10th of March 2026. Since paucity of time does not allow the matter to be taken up today, the interim order passed
Interim.
earlier, if any, shall continue.
Okay.
54.
Please con might হয়ে যাওয়া এক লাইন করতে হয়ে যাওয়া এক লাইন
Sorry, Lordship. Actually, item number 54 is, I'm here, Lordship. 53 not, Lordship.
53 discusses. তাকে 400 টাকা আসেনি আসে তো Yes, Mr. Das.
56, man. That has to be taken.
53.
53.
No, 53, we are on Mr. Bisa.
Item 53.
You have to unmute yourself, sir.
Oh, BC does.
बाकी इधर मत लोग ना. Yes, item
55.
No, 54. 54, 10th of March.
10th of March.
Interim order to continue.
Sorry, Lordship. Please.
55. May I please, Lordship? My lord, this pending, my lord, appeal, I am praying bail, my lord. Kindly short date, my lord, 1 year, more than 1 year he is in jail.
Short date, not on bail.
12th.
12th
12th.
of February.
Hearing day, my lord.
Hearing 12th Thursday.
Yes.
12th of February. Yes.
Diploma.
Paucity of time does not allow the matter to be taken up.
56.
On a hearing. We filed an application for suspension of the sentence. So court said, my lord, the entire matter can be heard. So this is how the matter was fixed today. So Lordship may give you a date so that we can.
19th February.
19th February. This is matter again on
February
19th
ki was
Paucity of time does not allow the matter.
19th.
For the record, the CD part is not available. That will be necessary.
Huh?
CD part. CD part is not in the scan copy, Lordship, because there the nomination part will be there in the CD part. In the entries, Lordship, it will be there, whether she has nominated on her own volition or not.
When can you have that part?
That will be called by the registry, Lordship. We already charge sheeted matter, case is already pending before the concerned court.
The nomination part, no, but that is one part of the, that was only one part of his argument. The other part.
48.
48.
Lordship had conveyed to me, if I have not misunderstood, Lordship, that if 48 part can be validated, Lordship, if her nomination is there, then Lordship will go to 36.
We'll have to see.
Lordship.
Because in one of the cases we found that the petitioner
Nominated.
had nominated
Yes.
somebody. So
And
we
I
have
had
to see.
other ground also, Lordship, 36 also.
We'll go to the other one if necessary. 36 he wants to argue at length.
Lordship.
36 he wants to argue at length. What
Yes,
other
Lordship.
what other ground did you have?
Lordship. Lordship may.
These are the only two things.
Lordship.
Another
Lordship, in between, I want to point out one thing, Lordship. In my first title also, Lordship, the police station number is, police station name is reflected as Pontal Bazaar instead of Pan Bazaar, Lordship.
Oh, you'll have to correct it then.
Yes, Lordship.
Otherwise, the correct this thing will not come.
And cost title.
Lordship, because entire scan copy was called for out of Lordship NDPS case number. Everything is correct, Lordship. Just arising out of PS case.
The trial court records received do not contain the
CD,
the case diary. Full stop. Call for the case diary from the trial court records.
Scan copy of the case.
Scan copy of the trial court records from scan copy of the case diary from the trial court records. Stop. List again on.
If Lordship will indicate the PS case number
of PS case number.
Pan Bazaar PS case number 161 of 2020.
List again on.
Lordship, My proposal, I may be allowed to correct Lordship.
No, no, it cannot be done by hand, Lordship, nowadays.
I'll file additional.
Additional affidavit has to be.
If I permit him, then he has to file the amended cost title. I can
Yeah.
permit him now without a petition, but he has to do it there. The counsel for the petitioner has submitted that day by
কোনটো? দিলো। এতিয়া দিছে নেকি মোক?
cost title reflects the police station as
As
Alton
Alton
Bazar
Bazar
instead
instead
of
of Pan
Pan
Bazar.
Bazar. And he
PSCS
allows it and
number,
be allowed to correct the same.
PSCS number
Permission is
161
granted.
of
Petitioner will
2020.
file an amended cost title before the registry.
Let's
with
again on.
the correct police station number. With the
My
correct police
proposal, I
station
may
name.
be allowed to correct
Yes, sir.
If I permit him, then he has to file the amended cost title. I can permit him now without a petition,
No, I
but
don't
he has to
need
do it there.
Yes, sir. Today, paucity of time, we'll have to give another date. Kindly tell us. দেখাই নাই দেখোন মুসলিম
Let me see.